the fakeness. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last.
All right, C3 in evidence for the purpose of the court record will be the multiple charges limiting instruction. Counsel have discussed a potential flight charge regarding defendant's departure. This closely models the standard instruction on flight. Both counsel have that. Any objection or comments from either side?
No, Your Honor.
Madam Clerk, Exhibit C4 in evidence, please. In addition, I prepared the standard instructions after the jury is sworn to be administered immediately before the opening statements. Any comments or objections by counsel?
No, Judge, thank you.
Madam Clerk, C5 in evidence, please. Thank you. All right, Ms. Lento or Ms. Schroen, would you place on the record the purpose of the 104 hearing this morning?
Thank you, Judge. Christine Lento, the purpose of the 104 hearing is to proffer statements made by the defendant. The state's also going to be proffering 4 videos from the Atlantic Heights Gym apartment complex from March 20th of 2021. The state is also going to be proffering a audio recording of a conversation with Corey and his mother occurring on April 2nd, 2021 at approximately 9 a.m. I know the court did already see 2 of the videos. I would leave it to the court's discretion if the court wants to view those videos again, but just for the purpose of completeness, we have them all today.
So we did various 104C hearings in advance. This one was reserved for today because of the particular witness involved. I already found that the detective from the prosecutor's office had properly authenticated the videos in terms of retrieval from the surveillance systems. My understanding is this witness would only be to identify the defendant and the child on the video. So is there a need to play all 4 videos, Mr. Gallucci?
No, Your Honor.
All right. So how do we want to? Do you want to just start with each video briefly and have the witness identify the defendant on each of them and the victim and
Your Honor, we could just play the videos and just, have her do the identifications, and obviously the audio recording we'd have to play for the court.
Right.
We also have a transcription for everybody as well for that. And
Right,
we do
but-
have some other testimony just in terms of the conversations, which would be oral statements of the defendant.
Right, but my point is I don't think you need to play the entirety of the 4 videos because you're going to play them again for the jury later this morning, right?
Exactly.
All right, so if you could just do whatever you need to do for the authentication aspect, and then we can deal with the entire video at the
Without
time
playing
of.
the video. Yes, Judge. Thank you.
Thank you. Go ahead, you can call your first witness then.
Yes, Judge. The state will call Brianna Micciolo.
Hi, Ms. Micciolo, good morning, ma'am. Come on in. If you could remain standing a moment, raise your right hand. The court reporter is going to swear you in, ma'am.
You solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. Have a seat. Please state your name for the record and spell both of your names.
Brianna Micciolo, Breanna. Micciolo is Micciolo.
Thank you.
Thank you, ma'am. Ms. Lento.
Thank you, Judge. Brianna, can you tell the court where do you live?
I live in East Brunswick.
And whom do you live with?
My boyfriend and daughter,
And what is your occupation?
data entry.
And do you have a son named Corey or CM?
Yes.
And is Corey no longer with us?
Yes.
And what day did Corey pass?
April 2nd,
And what is Corey's date of birth?
May 1st, 2014.
And how old was Corey when he passed?
6.
And who is Corey's biological father?
The defendant,
And what is the defendant's name?
Christopher Gregor.
And have you known Christopher Gregor for several years?
Yes.
Now calling your attention to Saturday, March 27th, 2021, did you attend Corey's flag football tryouts?
Yes.
And did you meet the defendant there?
Yes.
And did you have a conversation with the defendant about you taking Corey back to your home in Englishtown for visitation?
Yes.
And can you please tell the court about this conversation and what the defendant said?
The defendant just told me I could take Corey back for the weekend at my house.
Now calling your attention to April 1st of 2021, at approximately 8:41, did you have a phone conversation at Jersey Shore Medical Center with the defendant in regard to where you were?
Yes.
And can you tell the court about that conversation?
Yes, the defendant called me and he wanted me to bring Corey home. He didn't want him at the hospital, but I insisted because he was there for a child abuse exam, and we started arguing and he just started verbally attacking me.
Give me that date and time again, Ms. Lento.
Sure, Judge. The question was for April 2nd, April 1st of 2021 at approximately 8:41 p.m.
Thank you. Go ahead.
Now calling your attention to April 2nd of 2021 at approximately 3:30 p.m., did you have a phone conversation with the defendant in regard to your son, Corey?
Yes.
And can you tell the court what the defendant said in that phone conversation?
He told me Corey wasn't feeling good. That he was lethargic and he was throwing up and his legs hurt. He was just sick. And he asked me for Corey's insurance card and to send it to him.
And did the defendant tell you where he was taking Corey?
He said he was going to the hospital. He was taking Corey to the hospital.
And did he tell you which hospital he was going to take Corey to?
No.
For the judge. Your Honor, if I may approach what the witness, I do have marked what's been S-15-8 for identification. I also have a copy of the transcript of the 5 report.
Please. Thank you.
Do you have Brianna, I'm now showing you what's been marked S-15A for identification purposes, and do you recognize that?
Yes.
And can you tell the court what that is?
The flash drive?
And are you familiar what's located on that flash drive?
Yes.
And what is located on S15A is a audio conversation between you and Corey, correct?
Yes.
And that conversation is from April 2nd of 2021, correct?
Correct.
And that conversation occurred at about 9 a.m., correct?
Correct.
Now, did you record what's depicted on S15A?
Yes.
And how did the recording occur?
What do you mean?
Was the audio recording recorded on your cellular phone?
Yes.
And did you purposely record this event or accidentally record this event?
Accidentally.
Okay. And how did you discover the existence of S15A?
Detective Dennis Mitchell called me during the investigation and asked me if I knew about it, and he just wanted to know more about it.
Now, during the course of the investigation, did you provide your phone to Detective Mitchell?
Yes.
And Detective Mitchell works for the prosecutor's office.
Correct.
And did Detective Mitchell locate this audio recording on your phone, which you provided?
Yes.
Now, you were actually on that audio recording, correct?
Correct.
So you recognize your voice on the audio recording.
Yes.
And who else is on the audio recording in terms of you recognizing that person's voice?
Corey.
And you viewed this before you came to court today?
Yes.
Your Honor, permission to, well, I'm going to ask you this too. So I'm now showing you what's been marked S15B for identification, and can you tell us what that is?
It's a transcript of the video. Audio video.
So did you, prior to coming to court today, review the audio video?
Yes.
And did you review this transcription and compare it to the audio video?
Yes.
And does that transcription accurately depict the conversation, which is depicted in S15A?
Yes.
Your Honor, permission to publish S15A.
Any objection? Go ahead, please.
So it's his right, and he needs to see it, because when you're a doctor, I just want to make sure he sees that, okay?
Didn't start the
I'm not sure where it is. Yeah, he's inside. I don't know why the car's not here. That's strange.
So, Brianna, is that you speaking on that video?
Yes.
And is that Corey speaking on that video?
Yes.
And does that audio video accurately depict your conversation with Corey on April 2nd of 2021 at approximately 9 a.m.?
Yes.
Now, Brianna, I'm also going to show you what's been marked. I'm now showing you what's been marked S18 for identification purposes, and can you tell us what that is?
It's a flash drive.
Okay, and are you familiar what is contained within that flash drive?
Yes.
And contained within that flash drive, there are 4 videos, correct?
Yes.
And the videos have been marked A, B, C, and D, correct?
Correct.
And you reviewed those videos before you came to court today, correct?
Correct.
And in regard to video A, you were actually depicted on that video, correct?
Correct.
And you're familiar with the location which is depicted on that video, correct?
Correct.
And video A is a video of the Atlantic Heights gym complex from March 20th of 2021, correct?
Correct.
And that video starts when you had dropped Corey off that day to his father at the complex, correct?
Correct.
And so you're located on that video, right?
Correct.
And can you tell the court who else is located on video A, who you are familiar with?
Yes, the defendant and my son Corey.
Okay, and obviously you're familiar with the defendant, correct?
Yes.
And you've known him for several years.
Yes.
Now, bringing your attention to videos B, C, and D, you also viewed those videos, correct?
Correct.
And you're familiar as to who is located on those videos, correct?
Correct.
And can you tell the court who is located on those videos?
The defendant and my son Corey.
Now, the Atlantic Heights clubhouse gym area, you're familiar with, correct?
Yes.
And you've been there before?
Yes.
And about how many times have you been there?
Maybe once.
And you're familiar with the inside of the clubhouse gym?
Yes.
And are you familiar also with the outside of the clubhouse gym?
Yes.
Your Honor, at this point, we'd move to publish A with the foundation laid.
Any objection? Please go ahead.
He doesn't want to see it. Your Honor, at this point, we would publish the video. Does the court want to see video A?
Mr. Gallucci, do you have any objection to the authentication of that video? I don't. All right. So no, the court's seen the previous videos. I've already made detailed rulings under Evidence Rule 901 as to the authentication and the manner in which they were seized, retrieved, and the chain of custody, including the forensic analysis. The purpose of this hearing is simply for a witness with personal knowledge to be able to identify the defendant and to identify Corey. So whatever you feel you need to do just to handle that issue on the record, I think if you just play a few moments of the video, that should be sufficient.
You want us to do that now, Judge?
I think so. I think we just, outside the presence of the jury, I think the witness needs to identify
Sure.
the defendant and the child on the video.
Okay, Judge, we can publish A, and then we can publish, I guess, B, C, and D. B, C, and D. She's not actually there in that portions of the video, but if we show a portion of that, I believe she would be able to identify the parties.
Well, I find she's got sufficient familiarity with both of them to be able to identify them on her personal knowledge, unlike, say, a police officer who doesn't personally know the defendant or the victim prior to the incident identifying them.
Thank you, Judge. Permission to publish video A, please.
Please go ahead.
Thank you. Now, Brianna, you just viewed video A. Can you tell the court who is present on that video?
Myself, the defendant, and my son Corey.
And who is the adult male that is located on that video?
The defendant,
And who is a child who is located on that video?
Corey.
And can you tell the court where are you located in that video?
I was in my car.
And calling your attention now to, I guess we'll go with video B, if we get permission to publish.
Please go ahead.
Just tell me when to stop. I'll have to fast forward through some of it.
Now, Brianna, you just observed video B, and can you tell the court who is the adult male located in that video?
The defendant.
And who is the child located in that video?
Corey.
And have you been to that gym complex?
I have.
And does that accurately depict the gym complex at the Atlantic Heights clubhouse?
Yes.
And does it accurately depict what it looked like on March 20th of 2021 as shown in this video?
Yes.
Your Honor, in regard to videos C and D, I believe that there would be the same proffer by the witness.
Those would be redundant for the purpose of this hearing.
They are, Judge. There are videos that follow one another in a sequence.
Mr. Galucci, any objection to not playing those other videos at this hearing?
No, Your Honor.
All right, thank you. Any further questions?
No, Judge, thank you.
Mr. Galucci.
Good morning, Ms. Micciolo.
Good morning.
So, the recording on April 2nd, 2021, when did you first become aware of that recording?
When Dennis Mitchell called me and asked me about it,
Okay. And do you recall when that was?
I would say a few months later.
Okay. So it was still in 2021?
Yes.
And what, if anything, did he tell you?
He just asked if I knew there was a recording the day that Corey passed away.
And did you know that?
No.
Do you know how that recording happened then?
It seems like it was by accident.
So you accidentally recorded the drop off of your son?
Yes.
Okay. Had you ever done that before?
Early on in the custody battle, yes.
Okay. So, but early on when you did that, did you do it on purpose?
Yes.
Okay. So this time you're saying it was not on purpose.
It was not.
And when you became aware of it, did you recall that conversation with your son?
I think so, yeah.
So what do you do recall?
I remember it, yeah.
Okay. Did you remember it after you heard it?
Yes.
No further questions, Judge.
Thank you. Anything else from the
Just
state?
one quick question. Can you tell the court what happened with your phone as to how the audio recording occurred and the placement of your phone?
It was, I think, either on my lap or the chair.
No further questions, Judge.
Anything in light of that?
I'm good, Judge.
All right, ma'am, thank you for coming in. Please don't discuss your testimony with anybody. I'm sure the state's going to call you back later this morning.
Okay, thank you.
Just watch your step.
Can I see counsel at Sidebar before we go any further?
Thank you, Your Honor.
All right. We had a sidebar conference to discuss some logistical issues. I'll hear a proffer from the state as to the admissibility of any of those exhibits.
Thank you, Judge. In regard to the admissibility of the audio recording, the state is seeking to use that recording in the trial. The state is not offering the audio recording for the truth of the matter asserted. Rather, we are offering the recording to show Corey's condition on April 2nd of 2021 before he entered the defendant's apartment at the Atlantic Heights complex in Barnegat. In regard to the surveillance videos from March 20th of 2021, the state is proffering those videos as they occurred immediately before and during the Treadmill incident, which is count 1 of the indictment regarding and endangering. So obviously they're relevant to show our proofs and to show that the defendant did indeed commit the endangering.
Thank you. Mr. Gallucci.
Your Honor, I don't think a 33-second snippet of a telephone conversation that Ms. Micciolo wasn't even aware of is indicative of what Corey Micciolo's condition was. You hear him, you don't see him, you don't know anything except his voice, or he's saying he's going inside. So I think it's highly prejudicial for the jury to listen to a 33-second snippet immediately prior to him going into that house to show the jury that he was perfectly fine. We don't know if he was perfectly fine. You don't see any, you see a leg and you see a conversation. So I'm objecting to...
Just so I'm clear, I don't think it was a telephone conversation. I think it was she accidentally hit the camera, right? All right. And what about the other videos? Any issues of the other videos?
Judge, the only video I would also object to is the video when Ms. Micciolo drops Corey off to Mr. Gregor and they walk into the gym. I understand that the state wants to show that he was in a good physical condition. We have him in good physical condition. He's walking into the gym. He's in good physical condition. You watch him walk through the gym in good physical condition. You watch him get on a treadmill in good physical condition. So to add to that, this other video, I believe is just duplicitous. I can see no reason why we need 2 videos and a 33-second statement to say that Corey was fine.
Any reply?
Yes, Judge. In regard to the surveillance video, the first video is absolutely relevant to see the defendant's demeanor, which would go to the defendant's knowledge and purpose regard to committing the offense of endangering. Moreover, in the doctrine of completeness, it's a full record of everything that occurred that day. In regard to the audio voice recording, although it is short, it is highly relevant in the fact that through his voice, you can hear that Corey is speaking. You can hear that he is communicating. So for all those reasons, the state would submit that both of those exhibits are relevant and probative in the state's case.
So first I'll deal with S15A, a cell phone video evidently taken inadvertently by Ms. Micciolo on her cellular phone, April 2nd, 2021, which was played for the court. Defense counsel is correct. It's simply 33 seconds. It doesn't really contain any testimony. The child, according to the transcript, the child actually says, yeah, and then later says, are you going to call him? I could barely hear the yeah, but I did hear the child say, are you going to call him? There's really no video of either party. It looks like the interior of the car. Authentication is a low evidentiary standard. Under Evidence Rule 901 is the document what it purports to be. I clearly find it sufficiently authenticated. Is it relevant? Relevancy is under Evidence Rule 401. Does this have a tendency, in fact, to prove or disprove a issue which is material to the case? Here, the child's condition on the morning of April 2nd, 2021 is clearly material to the case. What weight the jury would give it, it's up to the jury. But in terms of being admissible, relevant, and authenticated, I find it satisfies the criteria for that. It may not be helpful to the jury, and in that case, the jury can disregard it, or they may place light weight on it, or they could place greater weight on it, but that's the function of the jury. In terms of S18, including the 4 videos on S18, we previously had a lengthy hearing where Detective Sergeant Raymond Coles of the Ocean County Prosecutor's Office testified as to how all those videos were retrieved, that the Prosecutor's Office had had actually seized the hard drive from Atlantic Heights, brought it to the Prosecutor's Office, left a temporary hard drive at the apartment facility, and extracted and downloaded a significant portion of videos and located those 4 videos. I incorporate my prior findings by reference as if set forth at length herein. Here I find that Ms. Micciolo has authenticated and identified Mr. Gregor and Corey in those videos. There's really no dispute about that. That was actually a formality, so to speak, but a necessary formality. So the state will be able to play those at trial. With respect to statements made by the defendant, that's governed under subsection C of Evidence Rule 104. Ms. Micciolo identified statements made by Mr. Gregor first on March 7, 2021, a Saturday at Corey's flag football game, where the defendant advised her that she could have Corey for the weekend. Obviously, Miranda does not apply there. No one's in custody. There's no charges pending. I find that the state's established that the defendant made that voluntary statement. It's up to the jury to determine what weight to give that. Next, Ms. Micciolo identified a call on April 1, 2021 at about 8:41 p.m. The defendant called and wanted Corey to be brought home from Jersey Shore University Medical Center. I find again that there's no custody or Miranda issues involved, that call has already been sufficiently documented forensically by Detective Sergeant Coles as well. I find the state's established the admissibility of that under Evidence Rule 104C by having a witness with personal knowledge of the same testify to it. There's a second phone call now the next morning, the next day, April 2nd, 2021, where the defendant was advising that Corey was not feeling well and he was going to take him to the hospital, was asking for insurance card information. I again find that there's no law enforcement involvement, there's no issues with Miranda. The state has established under Evidence Rule 104C that the defendant's statements were voluntary. In that regard, he initiated the call for the purpose of advising he was taking Corey to the hospital and asking for insurance information. So all those are admissible in front of the jury. Any other issues before we bring the jury over?
No, Judge, thank you.
All right. Take a few minutes to do that. If anybody needs a break or something like that, you can do that now.
Thank you, Judge.
Thank you, Your Honor.
All right, Sergeant Dugan, if you could have an officer go over and just go over. We'll bring the jury out. We'll have the clerk swear the jurors in. I'll read the instructions, and then we'll proceed to openings. Anything else from counsel before we do that?
Thank you, Judge.
Oh, I know what I wanted to ask you, Mr. Gallucci, on the limiting instruction on multiple charges. You had, at one point in the prior hearing, indicated you may want that addressed during the opening. Is that still the case?
Yes, Judge.
Where at the end of the state's opening, or?
I would do it at the end of my opening.
All right, at the end of both openings then. Any objection on that?
No, Judge.
All right, thank you. Good. All right, Officer Bennett, 10:06 a.m. If you guys a jury come out, please.
Jury out.
You can sit as soon as you come out, folks. We stand for you. As I've indicated to you, you're the most important people in the courtroom. The most important goal, of course, is a fair trial, but you're the most important people. We can't do this without you. Thank you. Please be seated, everyone. Juror number 12, sir, are you all right with the listening device? If you have any issues or whatever, just please tell me. So good morning again. Thank you so much for being here. Any concerns or issues you need to address at all? All right, seeing none, I guess Mr. Gallucci to introduce the attorney he has assisting him today.
Good morning. Assisting me is Andrea Ferranti. We discussed her during jury selection. Good morning. Thank you.
Thank you. So the first order of business, ladies and gentlemen, is we're going to swear you in as jurors. I do want to tell you, though, obviously you can see there is some media presence in the courtroom. There are some cameras. Just so you're aware, the cameras are not active when you enter and exit the courtroom or otherwise move about, and the cameras do not at all show any of the jury box. It's going to be for the witnesses or the attorneys. And then as you enter and leave, the cameras are deactivated. If you could please rise and raise your right hands, the clerk is going to administer the oath to you.
Do you swear or affirm to try the matter in dispute and give a true verdict according to the evidence?
Juror number 1.
Yes, I do.
Juror number 2.
Yes.
Juror number 3.
Yes, I do.
Juror number 4.
Yes, I do.
Juror number 5. Juror number 6.
Yes.
Juror number 7.
Yes.
Juror number 8.
Yes, I do.
Juror number 9. Juror number 10. Juror number 11.
Yes.
Juror number 12.
Yes.
Juror number 13.
Yes.
Juror number 14.
Yes.
Juror number 15.
Yes.
Juror number 16. Thank you so much. Please be seated. Members of the jury, it's my function at this time to give you certain instructions now that you've been sworn. As you know, this is a criminal case, so to assist you in better understanding your functions and duties, I'm here to tell you how the case will proceed. As I advised you last week, you are the sole judges of the facts. Your determination of the facts is to be based solely upon the evidence submitted during the course of this trial. When I use the term evidence, I mean the testimony of the witnesses who will testify from the witness stand next to me, and any exhibits which may be marked and admitted into evidence, and which later can be taken into the jury room by you for your review at the end of the case. The first order of business is the prosecutor's opening statement. In the opening statement, the prosecutor will present the state's contentions and will outline what she expects to prove. Following that, defense counsel, if he chooses, may make an opening statement. What is said in opening statements is not evidence. The evidence will come from the witnesses who will testify and whatever documents or tangible items that I admit into evidence and are received by you when you begin your deliberations. During the trial, the attorneys may make objections as evidence is offered, or they may address certain motions or applications to me. They have a right and indeed a duty to make objections and motions when it seems to them proper to do so. I likewise have a duty to rule upon any objections or motions based upon the law. If you hear me say an objection is overruled, it means that I am ruling against the attorney who made the objection. If I say an objection is sustained, it means I am ruling in favor of the attorney making the objection. At times I may exclude evidence. Anything excluded by me is not evidence, and therefore must not be considered by you in your deliberations. Sometimes these evidence questions or legal questions will be heard right in front of you in open court. Other times I'll ask the attorneys and the court reporter to come to sidebar. And there may be some times I'd ask you to go into the jury room because we have to discuss the matters at length. I realize that being confined in the jury room, particularly for 16 people, is not very pleasant, but I'd ask your patience and indulgence. And in fact, if I think one of those issues may take several minutes, 20 minutes or so, I may even give you the opportunity to go back to jury assembly where you have some more room. I appreciate your patience when you do this. I know it sometimes seems like there's a lot of downtime. For instance, even this morning we had some housekeeping matters we had to attend to, so I appreciate your patience when you waited in jury assembly. I'm sure that you realize that there are certain legal arguments or issues that just must be addressed outside of your presence. You should not conclude that because I rule one way or the other on any of these objections or motions or issues before me, that I have any feelings about the outcome of the case. I do not. But even if I did, you would have to disregard them since you are the sole judges of the facts. During the trial from time to time, there will be recesses. During those recesses, I direct you not to discuss the case amongst yourselves. And when we recess overnight, you must not discuss the case or the testimony with any members of your family or friends or any other persons, or provide an account of your jury service, including through any electronic means, such as social media or the internet. Don't talk to face with someone or use any electronic device like a cellular phone, an iPhone, a computer, social media, email, a chat room, a blog, Facebook, Twitter, or any other type of medium to communicate about the case. The reason for this, of course, is that you should not begin any deliberations until the entire case has been heard, that you've had all the testimony of the witnesses, you received the final arguments of counsel, and you've received my instructions on the law. It would be improper for any outside influence to intrude upon your thinking. If anyone should attempt to discuss the case with you, you should report that fact to me or to court staff immediately. As you know, you handed in your cellular devices today. Anything that is capable of internet access must be surrendered by you, as well as anything that's capable of taking any video or photographic images. Each time you come into the courthouse, the sheriff's officers will keep them for your safekeeping. Unless I instruct you otherwise, you may only use these communication devices when you're outside the courtroom during any recesses. I'd ask that you please be mindful of these instructions at all times. During jury selection, you were asked and responded to a series of questions from the court and from counsel. If during the course of the trial you realize that you may have made some type of misstatement or omission during your responses, or if circumstances arise which could cause you to have to change one of your prior answers, do not discuss that with your fellow jurors. Rather, tell one of the court officers and he'll notify me and we'll make a decision how to proceed with that. During the trial, you are not to speak or associate with any of the attorneys, the witnesses, or Christopher Gregor, nor are they permitted to speak or associate with you. This separation should not be regarded as rudeness, but rather a proper precaution to ensure fairness for both sides. If anyone connected with the case or any other person approaches you or attempts to discuss the case with you and influence you in any way, first, do not discuss it with that person. Second, do not discuss it with your fellow jurors. Simply tell a sheriff's officer and I'll be notified immediately. Your deliberations must be based solely on the testimony and the evidence admitted in this courtroom without any outside influence or opinions of friends or relatives. Additionally, do not read any news articles in print, on the internet, or on social media about this case. Obviously, there's some media coverage about it, but you have to make your decision from the evidence introduced in the four walls of this courtroom, not anything played on the internet. You're instructed to also not have anyone else view or listen to any of those accounts for you or discuss them with you. If anyone tries to do that, simply tell them the judge is giving you a direct order that you're not permitted to do that, and the person should not discuss it with you. Also, don't do any research about any of the topics, persons, places, charges, or things regarding this case. Don't look through newspaper articles or the internet about the lawyers, me, court personnel, through paper or electronic means. Don't seek any additional information on the subject matter of this case, including the laws involved. As I told you last week, please do not visit the scene depicted in this case, and don't look it up on the internet, such as through Google Earth or some other program. I'm sure you understand why this instruction is so important. Information from outside sources is not evidence. It is often based upon second or third hand information. It's purely hearsay. It's often inaccurate, and it also would not be subject to examination by the attorneys. A juror's improper use of outside technology threatens the very fairness of our system of justice and could result in us having to start the entire trial all over again, wasting your time, the attorney's time, all of our resources. And I'm sure you understand that. That's why I also instructed you about that last week during jury selection. If, however, some outside information comes to your attention, it's important that you not discuss it with your fellow jurors. You notify me or a court staff member immediately so that I can determine what action should be taken. The court and the parties rely upon your good faith and the fact that you have just been sworn as jurors to follow these instructions so that both sides may receive a fair trial. As you know, because this is so important, it's my duty to remind you at the end of each day not to do any outside research. Since you are the sole judges of the facts, you must pay close attention to the testimony. It is important that you carry with you to the jury room not only a clear recollection of what the testimony was, but also a recollection of the manner in which it was given. It will be your duty to pay careful attention to all of the testimony. If you are unable to hear any witness, please immediately advise me that by either calling out or raising your hand and asking me to have the witness speak louder or more clearly. As jurors, you're going to be required to pass upon all questions of fact, including the credibility or believability of the witnesses. As I've indicated to you, you're not permitted to visit the scene nor do any research or otherwise conduct your own investigation. Your verdict must be based solely on the evidence introduced in the courtroom. In addition, jurors are not permitted to take notes. Experience has shown that note-taking is often distracting. it is better to depend upon the combined recollection of all of the jurors rather than upon notes taken by one or more of them. At the conclusion of the testimony, attorneys will once again speak to you in summations. At that time, they'll present to you their final arguments based upon their respective recollections of the evidence. Again, the summations are not evidence, but it is your recollection of the evidence which is controlling. Following summations, you'll receive the final instructions from me on the law, and thereafter you'll retire to the confidentiality of the jury room to deliberate and consider your verdict. You are not to form or express an opinion on this case, but you are to keep an open mind until you have heard all of the testimony, heard the summations, and have had the benefit of my instructions as to the applicable law. At that time, you would be instructed to begin your deliberations. The responsibility of all jurors is to reach a fair verdict based upon the law as the judge explains it and upon the evidence presented in the case. The court's goal in every case is to seek jurors who will decide the case before them without prejudice or bias, because under our Constitution, everyone deserves a fair trial. Jurors fulfill this responsibility by remaining impartial or neutral until the jury reaches a verdict. Remaining impartial throughout the trial means ensuring that jurors are not guided or influenced by any biases or any preconceived ideas about the case. It is your duty to weigh the evidence calmly, impartially, and without any explicit or implicit bias, passion, prejudice, or sympathy, and to decide the issues on the merits. You as jurors should find your facts from the evidence adduced during the trial. Evidence may be either direct evidence or circumstantial evidence. Direct evidence means evidence that directly proves a fact without an inference, which in itself, if true, conclusively establishes that fact. On the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact can be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. It is not necessary that facts be proved by direct evidence. They may be proved by direct evidence or circumstantial evidence or a combination of direct and circumstantial evidence. Both direct evidence and circumstantial evidence are acceptable means of proof. Indeed, in many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. In any event, both circumstantial evidence and direct evidence should be scrutinized and evaluated carefully. A conviction may be based on direct evidence alone, circumstantial evidence alone, or a combination of direct evidence and circumstantial evidence, provided, of course, that it convinces you of a defendant's guilt beyond a reasonable doubt. Conversely, if the direct or circumstantial evidence gives rise to a reasonable doubt in your minds as to the defendant's guilt, then the defendant must be found not guilty. A simple illustration regarding direct evidence and circumstantial evidence may be helpful. Suppose the problem or issue is proving whether it snowed during the night. An example of direct evidence would be testimony by a witness indicating that he or she awoke during the night, looked out the window, and saw snow falling. An example of circumstantial evidence would be testimony by a witness indicating that when they went to sleep, it was not snowing and there was no snow on the ground. They slept throughout the entire night and woke up the next morning, looked out the window. Although it was not snowing, the ground was snow-covered. The former example goes directly to prove the fact that snow fell during the night, while the latter example establishes facts from which an inference that it snowed during the night can be drawn. As the judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take into account the following factors: the appearance and demeanor of the witness, the manner in which he or she may testify, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning their judgment, their understanding, a witness's ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the side for whom the witness testifies, the extent to which if at all, each witness is either corroborated or contradicted, supported or discredited by the evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony the witness has given, whether the witness made any inconsistent or contradictory statements, and any and all other matters in evidence would serve to either support or discredit his or her testimony. During your deliberations, you may ask, what is more reasonable, the more probable, or the more logical version? Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to discredit such testimony. Two or more persons witnessing an incident may see or hear it differently. An innocent misrecollection, like the failure of recollection, is not an uncommon experience. In weighing the effect of discrepancy, consider whether it pertains to a matter of importance or an unimportant detail, and whether the discrepancy results from innocent error or willful falsehood. Christopher Gregor stands before you on an indictment found by a grand jury charging him with committing the crimes of endangering the welfare of a child and murder. As to the indictment, Count 1 alleges endangering the welfare of a child, that Christopher Gregor, on or about March 20, 2021, in the township of Barnegat, County of Ocean, and within the jurisdiction of this court, having a legal duty to care for or having assumed responsibility for the care of CM, born May 1, 2014, knowingly did cause harm to CM, making CM an abused or neglected child, as defined in New Jersey Statutes 9:6-1, 9:6-3, and 9:6-8.21, and contrary to the provisions of New Jersey Statute 2C:24-4, subsection A2, and against the peace of this state, the government, and dignity the same. Count 2, murder, that Christopher Gregor, on or about April 2, 2021, in the township of Barnegat, County of Ocean, and jurisdiction of this court, did purposely or knowingly cause the death of, or purposely or knowingly cause serious bodily injury resulting in the death of another, specifically CM, contrary to the provisions of New Jersey Statute 2C:11-3, subsection A, and against the peace of this state, the government, and dignity the same. The indictment is not evidence of the defendant's guilt on the charges. An indictment is a step in the procedure to bring the matter before the court and the jury, for the jury's ultimate determination as to whether or not the defendant is guilty of the charges stated in it. The defendant has pleaded not guilty to the charges. The defendant on trial is presumed to be innocent, and unless each and every essential element of the offenses charged is proven beyond a reasonable doubt, the defendant must be found not guilty of that charge. The burden of proving each element of the charges beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. It is not the obligation or duty of the defendant in a criminal case to prove his innocence, nor offer any proof relating to his innocence. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases or heard of the civil standard, where you were told that it was necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proofs must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest and reasonable uncertainty in your minds about the guilt of the defendant after you have given full and impartial consideration to all of the evidence. A reasonable doubt may arise from the evidence itself or from a lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt is proof, for example, that leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. If, based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, then you must find him guilty. If, on the other hand, you are not firmly convinced of the defendant's guilt, you must give the defendant the benefit of the doubt and find him not guilty. You will note that a jury of 16 has been drawn in this case. We do that so obviously if anyone has an emergency or gets sick and can't continue, there'll be enough jurors to continue. At the conclusion of the case, after the evidence has been presented and the court has provided its charge, there's going to be a random selection of 4 jurors, or however many we have in excess of 12, who will then serve as alternates. The remaining 12 jurors will deliberate and return a verdict. At this point, we do not know who the alternates will be or whether or not their services will be utilized. Thus, I respectfully request that all jurors pay attention to the evidence as it is presented and to the court's rulings which are applicable to the case. Thank you for your attention. Now we'll proceed with the opening statement by the state. Ms. Strong.
Thank you. Corey Travis Micciolo. He liked the solar system. He liked to play outside. His mom describes him as silly and happy. Corey was 6 on April 2nd, 2021, when his father murdered him. His father is this defendant, Christopher Gregor. This case is about Corey and how Corey became the ultimate victim of this defendant's punishment and abuse. During the course of the trial, you're going to hear from a number of witnesses and see a lot of evidence. You'll learn that on May 1st of 2014, Corey was born to Brianna Micciolo when she was just 17 years old. This defendant didn't come into Corey's life, and neither did the Gregors, until Corey was 4 or 5. Back in March of 2021, Corey's parents hadn't been together, but they shared custody. Corey lived with the defendant, and his mom had visitation. On March 20th of 2021, Corey's mom picked him up for a visit. They went to Pennsylvania, and they saw their family. They were supposed to be back at about 3 or 4 o'clock. They were in Pennsylvania, there was traffic, and they were running late. Corey's mom told the defendant that. But Brianna's lateness, you'll hear, was pissing him off. He told Brianna to drop Corey off at the apartment complex's gym and meet him there. So she did. Corey and the defendant went into the gym, and you'll see what happened next. Because that gym had a surveillance system, and you will see what this defendant did to his son inside that gym. After that day, when Corey went back to school during the week, his teacher, his first grade teacher, started to notice some bruises on Corey. She was concerned. She's going to tell you that after March 25th of 2021, Corey was never physically back in person in school ever again. During this time, Corey's mom was also concerned. She had seen bruises as well. She was so concerned that she filed an emergent application with the court to get custody. On April 1st of 2021, Corey's mom picked him up for her only visitation she had had that week, or during the week, which was 3 hours, and she brought him to a pediatrician. Corey spoke to the pediatrician. The pediatrician saw Corey's bruises. She too was concerned. So she sent Corey and his mom to a local hospital nearby. Ultimately, Corey was seen at Jersey Shore University Medical Center. And while at Jersey Shore, doctors looked at Corey's body. They checked his lungs. They checked his bones. They checked his labs. And shortly after 1 o'clock in the morning, or around there, Corey was discharged. He was medically cleared for release because there was nothing wrong with Corey's lungs. There was nothing wrong with Corey's bones and his labs were normal. Corey was fine except for his bruises. Now, Corey's mom tried to bring Corey back to the defendant. Her visitation was over, and while they were at the doctor earlier, she learned that her application for custody had been denied in that regard, but that a child abuse examination had been ordered within 7 days by a specialist. And so, in trying to keep with the visitation schedule, she contacted the defendant and tried to bring Corey back. But he didn't answer. And so, since it's after 1 o'clock in the morning, Corey's mom and Corey go back to her house in Englishtown. And the two of them get home, everyone's asleep, they go in the basement, and they go to bed. That's where her room is. Corey wakes up in the morning, he has his breakfast, his mom dresses him in clean clothes, and he's with his mom the whole time. And she drives him back to the defendant's apartment in Barnegat. Corey and his mom sat in the car in the parking lot, and they said goodbye for what would be the very last time. Corey was walking. Corey was talking. Corey was fine, except for his bruises. By 9:03 a.m., Corey was back inside the defendant's apartment. And you'll hear that the defendant wasn't happy. But he told people, Corey's okay, Corey's all right. Except by 3:48 p.m., this defendant carried Corey's nearly limp body into Southern Ocean Medical Center. He reported that Corey was sleepy and had thrown up. Corey was admitted quickly. He was brought to room 6 in the emergency department. Corey coded. He was intubated. He coded again. He lost his pulse. And by 5:03 p.m., Corey was pronounced dead. This defendant, shortly after, walked out of the hospital, got into his car, and he left. Left the hospital, and he left Corey. You're going to hear from witnesses in this case that will tell you that defendant was found in Tennessee on April 4th. Now, a forensic pathologist that reviewed Corey's autopsy and his medical records is going to testify. He's a doctor. And he will tell you that Corey was a once healthy 6-year-old boy that died from blunt force trauma. He will describe for you the contusions on Corey's body all over in different stages of healing. He will tell you that the inflammatory response throughout Corey's body was acute. He's going to describe that Corey's heart and liver were both lacerated. Now, what you won't hear is that Corey was struck with a bat, stomped on by the defendant. You're not going to hear that. Because the only people there in that apartment were the defendant and Corey. But what you will hear is that the only people that were in that apartment were the defendant and Corey. And that the serious bodily injury that Corey sustained while with the defendant, and only the defendant, were so catastrophic that they ended his life. Now, there are 2 charges in this case. The first, endangering the welfare of a child, and the second, murder. The state must prove both beyond a reasonable doubt. That means you're firmly convinced, and that's a burden the state embraces. That first count, endangering the welfare of a child, is for what this defendant did to Corey in the gym on May 20th, 2021. And that second count is for what this defendant did to Corey on April 2nd, 2021. That's the murder. In order to prove a murder, the state has to demonstrate that a defendant acted purposely or knowingly. But rarely is there a person that can come into court and tell you what someone was thinking when they engaged in a particular act. So how do we prove that to you? We have to look at all the things the defendant was doing before, during, and after those crimes. Now, an expert in digital forensics will testify, and he'll tell you that he examined the defendant's cell phone. And from the defendant's cell phone, he was able to learn that throughout the day on April 2nd, 2021, the defendant was texting with a female associate, making plans for that night. On that same date, 3 hours before Corey died, he took a selfie with Corey on the couch. He also ordered McDonald's during that afternoon, and he did a search on his phone for loss of consciousness, sleepy, and nauseous. You're going to have information before you, and I'd ask you to consider it, about what this defendant was doing all day, at home, at the hospital, after he left. What he was saying to the people at the hospital, to Corey's mom, and everyone else. His texts, his phone calls, his web searches, his selfie, even his garbage. I'm going to ask that you pay attention to all of that. And when you do that, please pay attention to what's happening to Corey that day, that afternoon. On April 2nd, 2021, when Corey was brought back to his father, he vomited. He defecated in his pants, and his body was slowly shutting down. Consider what the defendant's doing while you consider what's happening to Corey. There were a lot of people in Corey's life, and you'll hear about some of them. Some might be positive, and some might not. But don't let that derail you. You all came here to serve as jurors in this case with everything that you need. And those are your life experiences and your common sense. Use it. Corey was alive and well at 9 a.m. when he was with his mom, and he was gone by 5:03 p.m. after only being with his father, this defendant. The state submits that after you've heard and seen all of the evidence in this case, you will be firmly convinced that this defendant is guilty of abuse and murder. Because healthy 6-year-olds don't just die during the course of a business day, and neither did Corey Micciolo.
Thank you. Mr. Galucci.
In August of 2017, Christopher Gregor was studying for his master's degree at Johns Hopkins University in Baltimore, Maryland, and he was also employed by Urban Teachers, which was a company that employed people to teach in urban areas. When he found out he was being sued for child support for a child he had never met, nor did he know he fathered. And that's where our story begins. Once again, I'm Mario Galucci, along with Andrea, and we represent Christopher. And although Ms. Schron just gave you a tidy little box with a little bow around it, that is far from what we believe the evidence is going to show you. As a matter of fact, the judge just told you that nothing Ms. Schron said is evidence. As a matter of fact, nothing I'm telling you right now is evidence. The only evidence you're going to hear is going to come right from that chair. And I'm going to tell you right now that our version of this evidence looks nothing like Ms. Schron's evidence. The evidence is going to show that Christopher was notified by a court document that he had to take a paternity test, and that was in 2017. You will hear that by court and whatever, by 2018, 2019, he learned that he was the father of Corey in order to pay child support. But he decided he wasn't going to just do that. he wasn't going to just pay child support. He was going to be a father. And he, along with his family, decided that they were going to embrace Corey and bring them into his life. At the time that Christopher learned he was Corey's father, the mother, Brianna, was living with her mother and another individual. And you will learn that that individual and Brianna split up. And it was right after that split up that they notified Christopher that he owed them child support. You will hear that Christopher decided to move in with his family in Monroe, New Jersey, right here. His father David, his mother Carolyn, and they took care of this young boy. They bought him a bicycle. They taught him how to ride, taught him how to play soccer, taught him how to play baseball, taught him how to play football. And at that time, they shared custody with the Micciolos. Then, somewhere around March of 2020, because of some challenges that Brianna Micciolo had, she no longer had custody of Corey, and custody went to Mr. Gregor. He was given full parental custody, and Ms. Micciolo was not to have any visitation with Corey. And as those challenges continued, your evidence will show that Rebecca Micciolo, Brianna's mother, asked to have visitation, which was granted. And at that time, Brianna was still not able to interact in Corey's life. You will see that through time, Brianna came back into Corey's life, thanks in part to the Gregor family, who assisted her somewhat to get through her challenges, and then agreed slowly to give her visitation of Corey, and they did. Once all of this happened, though, you will see that the Micciolos and the Gregors became like the Hatfields and the McCoys. It's unbelievable what you're going to hear in this case is evidence between the two families going back and forth over this poor child. But you will see, and what I will agree with, is what Ms. Schron just told you about a treadmill video. You're going to see that on March 20th, Christopher takes that young boy into a gym that's part of his residential complex. And in that gym, you see him put Corey on the treadmill, and he begins to work out while he's watching him from across the room. At some point, you're going to see Christopher go over to that treadmill and speed it up. And you're going to see Corey fall. And you're going to see him pick that boy up 6 times. And 6 times put him back on the treadmill. And I'm going to tell you right now, you're not going to like him. And I don't care if you like him. When you see that video, you're going to be horrified. You're going to be mortified. But I'm telling you right now that the evidence you're going to see of Corey's death had absolutely nothing to do with that treadmill. As a matter of fact, the treadmill incident was on March 20th. And between March 20th and April 2nd, Corey spent a significant amount of time with Brianna, spent a significant amount of time with Christopher, and actually tried out for a flag football team here in Ocean County, and did so well in the tryout that the coach actually had discussions with Christopher to raise him up a level. you will hear that Brianna became suspicious of some bruises. Bruises to his chest, bruises to his arms. And I submit to you, those bruises did occur from treadmill. They occurred from football. They occurred from boys being boys. You'll hear testimony that on a regular basis, Christopher would take him to a field across the street and play football with him like any other dad, that he practiced with him for this tryout. You hear testimony that Christopher himself was actually an athlete who competed in football. You will hear that when she sees the bruises, Ms. Micciolo, that she makes an emergency application to the court to regain the full custody, by the way, which she never, ever had gotten back from March of 2020. And that application was denied. So, she goes to DCP&P. They start an investigation. They tell her, take her to the pediatrician. And she chooses Ivy Pediatrics. She goes to Ivy Pediatrics, and they do an exam. They don't really find too much wrong with him, except he has bruises. They do blood work. They do tests. Healthy. Just like Michonne told you. Healthy. But they recommended to her that she follow up and that they would want to take her to Jersey Shore Medical Center to follow up on a child abuse allegation from the treadmill. You will see that Corey disclosed to the doctor at Ivy that my dad made me run on the treadmill, that I fell on the treadmill, and I also fell playing football. You will hear that she went against the advice of Ivy Pediatrics and left. And she took him to another hospital, Community Health Center, I believe it's called. And at that hospital, they did another evaluation. And during that evaluation, Corey was healthy, had a few bruises, but still suspected child abuse. We recommend to you that we take Corey to Jersey Shore Medical Center. What does Brianna do? She leaves the hospital against medical advice. She leaves. She does at some point now take him by herself to Jersey Shore Medical Center, where he undergoes an evaluation. And you're going to hear that when he was at Jersey Shore Medical Center, they found that he had a possibility of something called sepsis, which you'll understand from a doctor. I'm not a doctor, I'm a lawyer. But doctors are going to testify here. And you're going to understand that sepsis is your body's reaction to an infection. And it's a rapid response to that infection. And that rapid response, you're going to hear from doctors, will tell you, can show a child is loopy, disoriented, nauseous. And Jersey Shore Medical Center told her, Brianna, leave the child here. And she did not. She took Corey home, signed papers against medical advice. She took him home. So she's running from hospital to hospital to hospital, making emergency applications, you're going to hear, making complaints to DCP&P. So what does she do next? She's so concerned. You're going to hear how concerned she is. The evidence is going to show you how concerned she is for her son's safety. You're going to hear evidence that she was so concerned, she brought him to Christopher. Because her visitation was over. Remember, she didn't have full custody. Her visitation was over. And you're going to hear evidence that when Corey came home, he was tired. And Christopher did not find that to be unusual. Because often, by the way, Christopher lived in Barnegat, Brianna lived up in the Englishtown area. You'll hear testimony that actually, at some point, they were together and actually looking at houses together. You can hear evidence of that. But when he arrived, he was tired. And yes, Christopher did not find that unusual because he would often come back from Brianna's house and he was tired. So he looked in bed. And he slept. And he's on the phone with a woman, I believe her name is Marcy Brogner, and they're making plans to go on a date. And he's talking to her about what's going on in the house, that his son is there, that he's tired, that he's sleeping. And then you're going to hear testimony, I believe, from his mother, Christopher's mother, Carolyn. Because at some point, Christopher gets concerned because Corey's now been sleeping for a long time. So he calls his mom. Mom, I'm concerned. Corey has been sleeping quite some time now. And his mother just said to him, it happens every single time he comes back from their house. Let the kid sleep. So let him sleep. Then he ordered Grubhub. He ordered a Happy Meal, assuming that at some point Corey would awaken. And he did. He woke, said he wasn't feeling well, he had some milk, and he went back to bed on the couch. You're going to see that Christopher took a picture of Corey on that couch and sent it to this woman, Marcy Brogner, about how Corey was sound asleep on the couch. You're going to hear testimony that when he did awake, he was complaining of leg pain, serious enough that Christopher was concerned. He began to throw up. You're going to hear testimony that he was loopy. You're going to hear testimony that he looked like he was drunk. And you're going to see Christopher drive him to Southern Ocean Medical Center. And you're going to see him pull up to the emergency department. And you're going to see him carry that little boy into a hospital. And you're going to see him standing there holding that child in his arms, which seems like hours, before anybody comes to help him. And they do. And they come and they help him and they take Corey away. And they start to do some testing. And then they decide they need to do a CAT scan. And while during the CAT scan, Corey seizes, goes into cardiac arrest. Life-saving techniques are now used to try to revive him. And he dies. And it sucks, because he's a kid. No child should die. No child should die. But it's not murder. And you're going to hear testimony from doctors and experts. You're going to hear testimony from Dr. Larkin, who, by the way, Dr. Larkin has no skin in the game. This is a doctor that comes to the hospital. He's from the Office of the Chief Medical Examiner here in Ocean County. He has no idea what the relationship is between Christopher and Brianna and Christopher and Rebecca. He's got no clue. He just evaluates the child by science and medicine. Dr. Larkin found that Corey's blood results from Southern Ocean showed incredibly high white blood count, high glucose, and high lactic acid. And said that's all indicative of sepsis caused by an infection. The same sepsis that Jersey Shore Medical Center told Brianna Micciolo, do not take this child from the hospital. He possibly has sepsis. We need to evaluate him. Chief Medical Examiner here in Ocean County, his evaluation, you're going to hear evidence, sepsis, infection, not murder. A CAT scan ordered after Corey's death by Dr. Larkin, evidence will show, showed the possibility of pneumonia. Pneumonia is an infection, and an infection causes sepsis. So the Ocean County Medical Examiner, the first person to evaluate Corey, which, by the way, is 12 days after the treadmill. 12 days. You're going to hear testimony that when he gets to Southern Ocean Medical Center, there's no report of any additional bruising since March 20th. You're going to see there's no signs of, I believe Ms. Sharon said, a hit with a baseball bat, stepped on, I don't know what she said, whatever she said. You're going to hear evidence that doesn't show any proof of any of that. As a matter of fact, their own chief medical examiner, who did the autopsy, was inconclusive and could not come up with the cause or manner of death yet, pending investigation and toxicology reports. And he said, their chief medical examiner said that the injuries sustained to Corey were all due to life-saving techniques. He left the hospital. He was distraught. He was upset. He told the nurse, I need privacy. And he left. You're going to hear testimony that he called his parents immediately. Said Corey passed. They, Dave and Carolyn, you will hear, went immediately to the hospital and called the Stafford Police Department to tell them their grandson had just died in the hospital. You need to do an investigation here. They reported it. What did Brianna and Rebecca do immediately? Talk about him leaving. Rebecca and Brianna immediately turned to social media, where they tortured and crucified that man, posting a picture the same day of him in a prison outfit behind bars, wishing him death. They formed a chat group on Facebook dedicated to Corey, but evidence is going to show it really wasn't dedicated to Corey. It was dedicated into harassing the Gregor family. So much so, you're going to hear testimony that both Brianna and Rebecca were arrested in Monroe, New Jersey, and pled guilty for harassing Dave and Carolyn Gregor by protesting in front of their house, putting up posters on
Objection,
telephone.
Judge.
You wanna approach Sidebar?
Yes, please, thank you.
All right, ladies and gentlemen, I need to give you some instructions. First, as you've heard me say, and I think the attorneys agree, what is said in opening statements is not evidence. Any representations that the attorneys have made to you are their anticipations that the evidence is going to show certain things, particularly when we get to things like medical conditions, observations of physicians. The attorneys admittedly are not doctors. So you're to accept these opening statements exactly as they're intended, what the lawyers claim they think they can prove in the case. If the lawyers are not able to adduce evidence which proves those things, then you're to disregard those parts of the opening statements which made those representations which were not later backed up by evidence. Next, there's just been an issue of whether or not there were some charges against the Micciolos that resulted in some disposition. So first, the parties dispute whether or not there was a disposition of any kind of finding against the Micciolos. That has not previously been presented to me. So what I'm going to do is when that's presented, I'm going to make a ruling on whether that's admissible. Typically, municipal court level offenses are not admissible as proof of anything. Only if someone is convicted of a crime and they testify as a witness, and by a crime I mean a superior court level offense, would that evidence come in, and then I would give you an instruction as to how you analyze that conviction based upon the evidence. Here it's undisputed that there's no such conviction for a crime. So I'm going to ask you to disregard that reference right now that there's been some disposition in municipal court. If and when we come to that point, I'm going to make a ruling about what, if anything, you're allowed to consider in relation to that disposition in municipal court. At that time, if I allow it into evidence, I'll give you a specific instruction, and you're only to consider it for that limited purpose. But at this point, there's clearly no criminal conviction, so you should strike that part from your recollection. Mr. Gallucci is going to move on. I appreciate your time and attention. Mr. Gallucci.
So you're going to hear testimony that it was as a result of threats made to the Gregor family that Christopher stayed away. He was afraid to come back to New Jersey. But when contacted by his family that he was wanted for questioning, you will see GPS that shows him actually heading back to New Jersey to speak with the police. He is stopped, and I believe it's Alcoa, Tennessee. Not because they were looking for him. They were looking for his car. He was free to leave. They took his car because they had a search warrant. When they searched his car, they found a cell phone, maybe some other things. And then he came back to New Jersey. Didn't stay away. Didn't run away. You're going to hear testimony from 2, maybe 3 experts. You're going to hear testimony from Dr. Andrew, who's a forensic pathologist, I believe, from New Hampshire. I believe they're going to call him as an expert. You're going to hear from our expert, Dr. Michael Bodden, who's here in New York, and they both completely disagree on the result of Corey's death. Dr. Bodden, supported by medical records, is going to testify that Corey died from sepsis as a result of pneumonia, natural causes, that the bruises from March 20th had absolutely nothing to do with his death, had nothing to do with his sepsis, and that any bruising he had now was absolutely directly related to the life-saving techniques at the hospital at Southern Ocean Methodist. Now I get to that point where I want you to remember that you guys were chosen by all of us out of hundreds of people. Hundreds of people we went through. And we chose you because we all believed you would be fair, you would be impartial, you would listen to their evidence. I don't have to give you any evidence. I'm going to give it to you, but I don't have to. And I know you will listen. And this is important, as Judge Ryan explains to you all the time. This is one of the most important things you could do as a citizen. He uses the example that our men and women are fighting in foreign countries and dying. So you can sit here right now. This is an unbelievable, not only civic responsibility, but a human responsibility. You, as a human, are going to judge another human. And that is an awesome responsibility. And I know you all take it very seriously. Thank you.
All right, ladies and gentlemen, before we go any further, it's my function to give you some instruction on the multiple charges you're going to consider. This is a relatively brief instruction. It's not like my opening instructions to you. It's only a page and a half. So, as you know, there were two charges in the indictment: endangering the welfare of a child and murder. They are separate offenses by separate counts in the indictment. In your determination of whether the state has proven the defendant guilty of the two crimes charged in the indictment beyond a reasonable doubt, the defendant is entitled to have each count considered separately by the evidence which is relevant and material to that particular charge, based upon the law as I will give it to you in my final instruction at the end of the case. The state's going to be introducing evidence which it contends supports the charge of endangering the welfare of a child, as set forth in count 1 of the indictment, allegedly occurring on March 20, 2021. Included among that evidence is a video from the gym at the Atlantic Heights apartment complex. You may consider this video as evidence of the charge in count 1 and give it what weight you deem appropriate, whether that be great, slight, or none at all. However, you cannot consider evidence in support of count 1, including the video, to make a determination as to whether the state has proven the allegation in count 2, murder, except as expressly set forth in this instruction I'm giving you now. As to count 2 of the indictment, murder, evidence of other wrongs, crimes, or acts committed on a different occasion is normally not permitted under our rules of evidence. Our rules specifically exclude evidence that a defendant has committed other crimes, wrongs, or acts when it is offered only to show that he has a disposition or tendency to do wrong, and therefore must be guilty of the charged offenses. Before you can give any weight to the evidence of what allegedly occurred on March 20, 2021, you must be satisfied that the defendant committed the other crime, wrong, or act. If you are not so satisfied, you may not consider it for any purpose. However, our rules do permit evidence of other crimes, wrongs, or acts when the evidence is used for specific, narrow purposes. In this case, the state is seeking to introduce the Treadmill video to determine the defendant's motive, intent, or absence of mistake or accident regarding the murder of CM allegedly occurring on April 2, 2021. In other words, the state's going to contend the evidence of defendant's conduct on March 20, 2021, the date of the alleged endangering offense, demonstrates the defendant's motive, intent, or absence of mistake or accident on April 2, 2021, the date of the alleged murder. Whether this evidence does in fact demonstrate the defendant's motive, intent, or absence of accident or mistake regarding the alleged murder of CM is for you to decide. You may decide that the evidence does not demonstrate the defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of CM and is not helpful to you at all. In that case, you must disregard the evidence in your consideration of count 2, murder. On the other hand, You may decide that the evidence does demonstrate defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of CM, and use it only for that specific and limited purpose. However, you may not use the evidence of what allegedly occurred on March 20, 2021, to decide that the defendant has a tendency to commit crimes, or that he is a bad person. That is, you may not decide that just because the defendant has allegedly committed some other crime, wrong, or act, he must be guilty of the murder charge. I have admitted the evidence of the defendant's conduct on March 20, 2021, to be considered in conjunction with the murder charge, only to help you decide the specific question of the defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of CM. You may not consider it for any other purpose, and you may not find the defendant guilty of murder simply because the state has offered evidence that he allegedly committed other crimes, wrongs, or acts on a prior date. As with all these instructions, they'll be given to you again in the final charge. I apologize, I neglected to introduce our official court reporters. I typically do that in the morning. I think I had expressed to you we would have an official reporter. This is our long-standing official reporter, Ms. Karen Holtz, who's been with the judiciary for many years. She's also assisted today by Deborah, who is herself a long-standing reporter, but new to the judiciary. They do amazing things. They actually are writing, not typing. They write a stenographic language, and then, if appropriate, are able to then prepare transcripts at a later date. But what can be very helpful if we need a readback of something, they're usually available to do that. So I thank them for being here, and I wanted to explain what was occurring. So it's time for our mid-morning break. Again, as with all breaks, don't form any opinions, don't discuss the case amongst yourself, don't do any deliberations. Please go in the jury room, help yourself to the things that are in there, and then when you're ready, after 10 or 15 minutes, give us a knock on the door. That'll give the state some time to get its first witness. Thank you so much.
All rise.
Yeah, you can go.
Folks, just a reminder, do not open this door, okay? We will knock before we open it to let you out, okay? Do not open it. Thank you.
11:18 a.m., the jury's back in the jury room. Anything from counsel outside the presence of the jury?
No, Judge, thank you.
All right. So everyone's welcome to stay if you'd like, but obviously you don't have to. It's an open public courtroom, so you can come and go. And I just ask that if a witness is in the middle of testimony, please try to be very discreet as you come and go. So if you'd like to leave, now would be a good time. But again, you're not required to do that. You can stay for the whole proceeding. Thank you, folks. Please be seated. Ladies and gentlemen, thank you. We're going to proceed with the state's case. The state's going to call its first witness, Ms. Strone or Ms. Wendell.
Thank you, Judge. The state would call Brianna Micciolo, please.
Brianna Micciolo.
Brianna Micciolo?
Please come up. Come on up, Ms. Micciolo. If you could remain standing, take the court reporter, she'll swear you in.
You solemnly swear or affirm the testimony you're about to give in this proceeding will be the truth? Yes. Would you have a seat, please? State your full name for the record and spell both of your names.
It's Brianna Micciolo, Breanna Micciolo.
Thank you.
Thank you, Ms. Hunter.
Brianna, just before we start, I just want to remind you that you're going to have to keep your voice up, okay? The jury's going to have to hear you. So, Brianna, how old are you?
I'm 27.
And what is your birth date?
November 7th, 1996.
And where do you live?
East Brunswick.
And whom do you live with?
My boyfriend and daughter.
And do you work?
Yes.
And what is your occupation?
Data entry.
Who is Corey Micciolo?
My son.
And when did you give birth to Corey?
May 1st, 2014.
And how old were you when you gave birth to Corey?
17.
And what grade were you in when you gave birth to Corey?
11th grade.
And who is Corey's biological father?
The defendant.
Man, take this microphone and just slide it right in front of you, okay?
Okay.
There it is, right in the middle there, as far as it goes.
That's as far as it goes.
Okay, let me turn it a little bit, Jason. I want you to pretend that you're basically speaking all the way to the end of the jury box, all right? All the jurors need to hear you and see you. If they can't hear you down there, it's like you're not testifying, okay?
Okay.
So I know it may be difficult, but please try and keep your voice up.
So who is Corey's biological father?
The defendant.
And what's his name?
Christopher Gregor.
And how old were you when you first met Christopher Gregor?
16.
And do you know what the defendant's birth date is?
It's May 1992.
Now, you're familiar with Christopher Gregor, correct?
Yes.
And you've known him for many years, right?
Yes.
And you see him located in the courtroom today?
I do.
And can you please point to him and tell us where he's seated and what he's wearing?
He's sitting over there wearing a suit.
Identifying Mr. Gregor, Your Honor.
So noted, thank you.
Now, is your son Corey no longer with us?
No. Well, yes.
And can you tell the jury the day he passed?
April 2nd, 2021.
And how old was Corey when he passed?
He was 6.
And what types of things did your son Corey like to do as a 6-year-old?
He liked reading, coloring, painting, playing outside.
And what type of demeanor did Corey have as a 6-year-old?
He was happy, silly, loving.
Permission to approach the witness, Your Honor?
Yes, certainly.
Okay. I'm now showing you what's been marked S1 for identification purposes. And do you recognize that?
Yes.
Okay. And is that a picture?
Yes.
And can you tell the jurors what that's a picture of?
Oh, that's a picture of Corey.
And did you take that picture?
Yes.
So you're familiar with
Yes.
your son Corey, who's depicted in the picture?
Yes.
Your Honor, permission to publish S1.
Any objection?
None,
Are you ready to get the evidence first?
We can move it into evidence, yes. Move into evidence and publish.
No objection to evidence?
No, Your Honor.
S1 in evidence.
Now, Brianna, can you tell the jurors who's depicted in that picture?
My son Corey.
And how old was he in that picture?
6.
And who took that picture?
I did.
And can you tell the jurors what you were doing when you took that picture of Corey?
We were at the park playing in the snow.
Okay. Now, Brianna, how old was Corey when the defendant entered his life?
He was 5.
And was there a paternity test?
Yes.
And how old was Corey when it was determined that the defendant was his biological father?
Around 4.
And calling your attention to October 28th of 2020, were you and the defendant granted joint custody of Corey?
Yes.
And when that happened, who became the resident parent of Corey?
Christopher.
And when I say resident parent, can you tell us what that means?
He resided with him.
And did you have visitation?
Yes.
And was this ordered by the family court in Middlesex County?
Yes.
Your Honor, permission to approach the witness, counsel?
Yes, of course.
The order? Yeah, sure. Thank you. Your Honor, permission to approach?
Yes.
Thank you. Brianna, I'm now going to show you what's been marked S2 for identification purposes. And can you tell the jury what that is?
It's a court order.
Okay, and where is it a court order from? Is it from the
Family court.
Okay, and on top of this order, is there a date present on S2 where it says filed?
Yes, it's October 28th, 2020.
Okay, and can you tell the jurors what the judge's name is on this order?
Judge Silva.
Okay. And going down into this order where it says it is on this 28th day of October 2020 ordered as follows, can you please read for the jurors what it says in number 1?
Yes. It says the party shall attend court-sponsored mediation on the issues of parenting time and defendant Christopher Gregor's name change application. Said mediation will take place at a date and time to be set by the court's mediator.
Okay, and continuing on, can you please read?
The party shall share joint legal custody of the minor child Corey, date of birth May 1st, 2014, pendente-like basis. Defendant Christopher Gregor shall continue to be the parent of primary residence, and defendant Brianna shall have unsupervised parenting time as follows.
Could you please continue?
Alternating weekends beginning November 6, 2020 from Friday at 5:30 until Sunday at 6 p.m. Brianna shall pick up and drop off Corey at Christopher's home.
Okay, can you continue on, Brianna?
Wednesday evenings from 4:30 p.m. to 7:30 p.m. Brianna shall pick up and drop off Corey at Christopher's home. No one except Brianna and Rebecca shall be present in the home during Brianna's parenting time. And whoever has their child during a scheduled extracurricular activity shall transport him to the activity, however the other parent may attend.
Okay, and then going to number 3, does it talk about the parties unblocking each other from the other cell phone?
Yes.
And then going to number 4, does it talk about the parties shall engage in co-parenting counseling?
Yes.
And then going to number 6, it talks about the parties being barred from making disparaging remarks, correct?
Correct.
And then it go on to give a holiday schedule for Thanksgiving and Christmas.
Correct.
And what does number 8 say, please?
Brianna Micciolo shall have Skype calls or FaceTime calls with Corey on Tuesdays and Thursdays and Saturdays and Sundays during the weekends when Corey is with Christopher. Similarly, on the weekends that Corey is with Brianna, Christopher shall have Skype or FaceTime with Corey on Saturdays and Sundays. Neither party shall record these calls.
Okay. And the caption of this order is, who is the plaintiff in the matter?
My mom.
Okay, and who is listed as the defendants in the order?
Myself and Christopher.
Now, Brianna, have you struggled with substance abuse?
Yes.
And have you specifically struggled with drugs?
Yes.
And can you please tell the jurors about this?
Yes. In my early 20s, I struggled with drug abuse. When I was younger, I went through a lot, and I feel like I used the drugs to suppress my emotions. I didn't really have the coping skills that I do now, and like I said, I was just going through a lot. But I've been clean currently for a long time.
And have you ever used drugs in front of your son, Corey?
No.
And can you tell us why you were granted custody of Corey in October of 2020?
I went through a drug program, and I provided clean urines, and I just fought really hard because I hated living without my son.
Now, calling your attention to September of 2020, where was Corey living?
In Barnegat.
Okay, and who was Corey living with?
The defendant.
And where did the defendant reside?
In Barnegat.
Okay.
Atlantic Heights.
Okay, when you say the Atlantic Heights, can you tell the jurors what that is?
It's an apartment complex.
And did the defendant move from his parents' home in Monroe Township to the apartment in Barnegat?
Yes.
And who else lived in the apartment in Barnegat with Corey and the defendant?
Just them.
Now, Brianna, in October of 2020, can you tell the jurors where you were living?
In Englishtown.
And what type of home did you live in Englishtown?
A townhome.
And who lived in the townhome in Englishtown?
Myself, my mother's boyfriend, and my sister.
And can you describe for the jurors what the townhome looked like in Englishtown?
It was 2 stories with a finished basement.
And where was your room located in the house?
In the basement.
And can you tell the jurors how come you were living in your mother's home in October of 2020?
I wasn't working at the time, so I couldn't afford it.
And about how far away is Englishtown, New Jersey from Barnegat, New Jersey?
About an hour.
Now, in October of 2020, what grade was Corey in?
He was in 1st grade.
And what school did Corey attend?
Cecil S. Collins.
And the Cecil S. Collins Elementary School, what town is that located in?
Barnegat.
Now, calling your attention to March 19 of 2021, did you have visitation of Corey that weekend?
Yes.
And can you tell the jurors when did your visitation start with Corey that weekend?
March 19th.
Okay, and that would have been a Friday night?
Friday.
And where did you go to have your visitation with Corey on Friday the 19th?
The defendant's home.
And why did you go to the defendant's apartment on the 19th to visit Corey?
The court order made it hard to go back to my house, and I just didn't want to fight with him. It was just easier than actually fighting with him.
Okay, and when you're talking about the court order, are you referring to the court order from October 28th of 2020?
Yes.
And are you specifically referring to subsection C, that no one except Brianna and Rebecca shall be present in the home during Brianna's parenting time?
Yes.
So during that time frame, Brianna, was it common for you to go see Corey at the defendant's apartment?
Yes.
And calling your attention specifically to the 19th, did you sleep at the defendant's apartment that night?
Yes.
And why did you stay at the defendant's apartment that night?
The next day I had something to do with Corey early.
And during that time period, was it common for you to stay over the defendant's home during your visitations with Corey?
Yes.
And was the defendant always there when you would stay at the apartment to visit Corey?
Yes.
He was always there?
Yes.
Okay. And what if the defendant had plans?
He would leave, and it would just be me and Corey.
Now, calling your attention to Saturday, March 20th at 2021, did you take Corey for the day?
Yes.
And did you previously discuss your plans with the defendant?
I did.
And can you tell the jurors where you and Corey went?
I took Corey to Pennsylvania to visit my dad for his birthday.
And what part of Pennsylvania did you go to?
Abington.
And what did you and Corey and your dad do in Abington, Pennsylvania?
We went mini golfing and we got ice cream.
And about how far of a drive would it be from Barnegat, New Jersey to Abington, Pennsylvania?
About an hour and a half.
And what time that day were you supposed to bring Corey back home from the visitation?
Between 2 and 3.
And when you were driving back to Barnegat, what were the traffic conditions that day?
There was a lot of traffic.
And what happened due to the traffic?
I was late.
And besides the traffic conditions, why were you also running late?
Corey was enjoying himself, so I didn't want to just rip him away from that.
And who did you tell that you were going to be late that day in bringing him back?
The defendant.
And did the defendant send you a text message on March 20th at approximately 3:04 p.m. about you being late?
Yes.
Your Honor, permission to approach.
Yes.
Brianna, I'm now showing you what's been marked S5 for identification purposes. And do you recognize those?
I do.
And can you tell the jurors what those are?
There are text messages between me and the defendant.
And you're familiar with those text messages?
Yes.
And are those text messages that were located in your cell phone?
Yes.
Okay, now during the course of this investigation, did you provide your cellular phone to the Ocean County Prosecutor's Office?
Yes.
And when did you provide your cell phone to the Ocean County Prosecutor's Office?
The day Corey passed.
And you provided your cell phone to Detective Mitchell?
Correct.
And by doing this, you voluntarily agreed that the prosecutor's office would search your phone?
Yes.
So calling your attention now to S5 in particular, at approximately 3:04, what did the defendant text you in regard to you dropping off Corey on March 20th, 21 at approximately 3:04?
He texted me, "When you get here, please just drop him off."
And what was your response?
I said, "Okay."
And then what did he say next?
He said, "You almost 2 hours late, what the fuck?"
And what did the defendant say next?
He said, "This Friday, however long late you are, is how long after 4:30 you can come."
Can you continue, please? What did he say next?
FYI, this is beyond pissing me off now. My entire plans for today are ruined.
What did you respond?
I'm driving as fast as I can. There was traffic. I'm sorry. And he said, "I don't care. Whenever you get here, we will take the difference in time from 2 o'clock until then, and that is how long we will add on to 4:30 for when you come on Friday now."
And then, can you tell us?
Yes. He said, "I'm at the clubhouse gym. Just drop him off here." I said, "Okay." And then again, I said, "He can't get in." And then I said, "I apologize for being so late, and I mean it. I'm not saying this because I want you to change your mind about Friday. I will come at 6:45, no problem. It's understandable, but I did want to tell you that there was no ill intentions there. I didn't mean to be so late."
Okay, so the text message that you're referring to regarding the clubhouse gym, can you tell for the jurors what time that text message is from regarding Corey not being able to get in?
At 4:14 p.m.
Thank you, Brandon. So, Brianna, on March 20th of 2021, at approximately 4:15, did you drop off Corey to his father at the clubhouse gym at the Atlantic Heights apartment complex?
Yes.
And had you ever been inside the gym located at the clubhouse gym?
I have.
And can you just briefly describe what the clubhouse gym looks like?
There's weights and Treadmills.
And where did you park when you dropped Corey off that day?
By the entrance of the clubhouse.
And did Corey have issues getting inside of the gym?
Yes.
And can you please explain what happened regarding Corey being able to enter the clubhouse gym on March 20th of 2021?
The door was locked, so I texted the defendant that he couldn't get in.
And then what happened after that?
He came and unlocked the door.
And what was the defendant's demeanor when he let Corey into the gym and then at that point in time?
He was very angry.
And at any point during this, did he come to your car?
Yes.
After you dropped Corey off on March 20th, 2021, when is the next time that you saw Corey?
I believe it was Tuesday.
Would that have been March 23rd,
Yes.
2021? And on that particular day, did you drive to Barnegat?
Yes.
And did you drive there to visit Corey?
Yes.
And where did you visit with Corey that day?
The defendant's home.
And about what time do you think did you arrive at the defendant's apartment to visit with Corey?
Maybe 4:30.
And that would have been your weekday visitation with Corey?
Yes.
So it would have been like after the school day?
Oh, yes. I'm sorry.
And where was the defendant when you visited Corey?
He was home.
And did you stay over the apartment that night?
No.
And what time did you leave the apartment?
I would say around 9:30.
And while you were with Corey, did you see any bruises on him?
I did. Yes.
And can you describe for the jurors the bruises that you saw?
He had a bruise on his forehead, and it was very odd shaped, and it kind of looked like an imprint of something.
And besides that bruise, did you see another bruise?
He had one on his chest. It looked like a scrape.
And where were you when you saw these bruises on Corey?
Corey and I went on a walk in the neighborhood.
And did you speak to Corey about the bruises that you saw?
Yes.
And where were you and Corey when you spoke?
We were on the walk.
And what was Corey's demeanor when you spoke to him about the bruises that you saw?
He just seemed upset and scared.
Now, calling your attention to March 26th of 2021, did you make a referral to DCP&P?
Yes.
And can you tell the jurors who DCP&P is?
They are the Department of Children's Protection and Permanency.
Or people know them as DIFUS.
Yeah.
And how did you contact DCP&P?
Through the hotline.
And why did you make a referral to DCP&P at this time?
I felt like Corey's abuse was getting really bad, and I felt like they needed to do something about it.
Now, drawing your attention to Saturday, March 27th at 2021, did you see Corey that day?
I'm sorry, what day was it?
Saturday, March 27th of 2021. Did you see Corey that day?
Yes.
And where did you see Corey?
In Stafford or Barnegat.
And why were you at Stafford or Barnegat to see Corey?
He was having flag football tryouts.
And where did you go to see the flag football tryouts?
I think it was South Jersey, like Stafford or Barnegat.
Okay. And did you see the flag football tryouts?
Yes.
And who brought Corey to the tryout?
The defendant.
And how did you arrive to the fields for the flag football tryouts?
I drove myself.
And why did you meet the defendant there that day?
He didn't want to drive with me because he didn't want to be seen with me. I'm too trashy.
And what type of contact was allowed for first grade flag football?
It's no contact.
What, if any, injuries did Corey sustain flag football tryout?
None.
After the flag football tryout, did you take Corey back to your house in Manalapan for visitation?
I did.
And where did you take Corey to?
My house.
And did you have a conversation with the defendant at the tryout about bringing Corey back to your home for visitation?
Yes.
And can you tell the jurors what the defendant said in regard to you bringing Corey back to your home?
He told me just to take him for the weekend.
And were you expecting that you were going to be able to take Corey home from tryouts?
No.
And that occurred during the tryout.
Yes.
Now, in regard to the court-ordered visitation schedule, did you and the defendant always follow what was specifically said in the court order?
No.
And can you tell the jurors why not?
I'm not sure.
Well, what about, would there be circumstances which would...
Oh, yes. Christopher would let me take him to my house knowing the people that he didn't want to be there were there a few times.
Okay. When did you bring Corey back to the house in Barnegat after you brought him to your home after flag football?
On Sunday.
And can you tell the jurors what time did you return Corey to his father the next day?
Around 6.
And while Corey was at your home after the flag football tryouts, what, if any, bruising did you see to his body?
He had a large bruise on his chest. He had, it looked like fingerprint bruises all over his arms and legs. And he had it was very large on his hip, on his side.
Now, besides the bruises, can you tell the jurors about Corey's physical condition?
He was normal.
Now, during your visitation with Corey at your home in Manalapan, was Corey exposed to anyone with COVID?
No.
And had anyone in your family attended a funeral?
No.
Had anyone in your family attended a mass gathering?
No.
At that time, what did you learn about Corey being out of school?
The defendant took him out of school for an apparent or exposed to COVID.
Did you confront the defendant about this?
Yes.
And what did the defendant do in response?
He blocked me.
On March 30th of 2021, did you contact the pediatrician about getting Corey an appointment?
Yes.
And can you tell the jurors why you contacted the pediatrician?
Well, because I suspected that Corey was being abused, and I went on the advice of a DCPMP worker.
Objection.
So sustained. You should strike that. That's hearsay. That someone else told her something. So you should strike that, not consider it. If the state calls that person, then we'll deal with it at that time. Thank you.
Did you get an appointment with the pediatrician?
Yes.
And what day was the appointment scheduled for?
April 1st.
And April 1st was a Thursday? And what time was the appointment scheduled for, Brianna?
Around 5.
And why did you make the appointment at 5?
Because that's when my parenting time was.
And who was the appointment made with? What pediatrician?
IV Pediatrics.
And did you have a conversation with the DCPMP caseworker?
Yes.
Without telling us the conversation, what was the caseworker's name?
Name?
Yes.
Mark Waltonowski.
Calling your attention to March 31st of 2021, did you file an emergent application for full custody of Corey with the family court?
Yes.
And can you tell the jurors why you did this?
I was in fear for Corey's life.
And was DCPMP involved in this process?
Yes.
Now, on April 1st of 2021, what time did you pick up Corey that day for visitation?
Around 4:30.
And after you picked up Corey, where did you take him?
To the pediatrician.
And what was the name of the pediatrician or the practice?
IV Pediatrics.
And what town was the pediatrician located in?
Tom's River.
And when you picked up Corey that day, what was Corey's demeanor?
He was fine.
And when you picked up Corey that day, what was his physical condition?
He still had some bruises, but other than that, he was normal.
And when you got to the pediatrician's office, did Corey speak to the doctor?
Yes.
And was Corey examined by the doctor?
Yes.
And did you speak to the doctor?
I did.
Now, based upon this conversation, where did you take Corey next?
The community medical center.
And where is Community Medical Center located?
I believe in Tom's River.
And why did you take Corey to Community Medical Center in Tom's River?
To be examined further, and he needed to get x-rays and blood work.
Okay. And while you were either at the pediatrician or on your way to Community Medical Center, did you receive the family court order regarding your emergent application?
Yes.
Your Honor, permission to approach?
Yes, of course.
Brianna, I'm now showing you what's been marked S17 for identification purposes. And can you please read the caption at the top of just saying that who the court order is from?
Honorable Patrick Bradshaw, JSC, Superior Court of New Jersey, Chancery Division, Family Part.
Okay. Now, calling your attention to this order, can you tell us who opened this court order?
I did.
Okay. And the court, can you read on the first paragraph, starting with, and the court having considered, what the court considered?
Objection.
What's the basic position?
How would she know what the court considered?
It's in the document,
Well, I
Judge.
think the question is that the order recites what the court considered. Do you have an objection to that?
Nope.
All right, thank you.
That's the question. Can you read off the order, please?
Right here.
Yeah, you could start with.
Okay, and the court having considered the paper submitted, and the court having reviewed a letter of investigatory findings submitted by the Department of Child Protection and Permanency, and good cause having been shown, it is on this first day of April 2021 ordered as follows.
Okay. And as the court order continues, you were denied your request for emergent custody, correct?
Correct.
And then continuing with this order, specifically in subsection 2, can you read for the jury what the court order says?
It says, upon recommendation by DCPMP, this court orders that the party's minor child, Corey, undergo a CPC evaluation as a part of its ongoing investigation.
Okay, and I could just stop you there. And a CPC evaluation, that would in essence be an examination for what was going on with Corey and the bruising, correct?
Objection.
It doesn't matter, Judge. I can withdraw the question.
Well, it's leading, so
Okay.
it's distinct.
We'll go to subsection 3, if you could read for what the order says.
The court also orders the parties to confer with one another to agree upon a date and time in which Corey shall be made available for an examination by his pediatrician regarding Corey's bruising within 7 days of this order.
Okay. Now, after Corey was at the pediatrician, where did you take him next?
To the hospital.
And what hospital, again, did you take him to?
Community Medical Center.
And how did you drive Corey to Community Medical Center?
In my car.
And what was Corey's physical condition while in the car?
He was okay.
And can you tell the jurors what Corey's demeanor was when he was in the car?
Same as always, he was normal.
And about what time did you arrive at Community Medical Center?
Probably like between 6 and 7.
And was Corey examined at Community Medical Center?
Yes.
And what department was this in?
The emergency room.
And did Corey speak to the doctor?
Yes.
And did you speak to the doctor?
Yes.
And based upon your conversation, where did you take Corey next?
Jersey Shore Medical Center.
Now, while you were at Community Medical Center, before you got to Jersey Shore, did the defendant send you a text message as to where you were?
Yes.
Your Honor, permission to approach.
Yes.
7. Mario, wanna see this? Okay, I'm now showing you what has been marked S7 for identification purposes. And do you recognize these?
Yes.
And are these what?
Text messages between me and the defendant.
Okay. And calling your attention on S7, in particular to the first text message contained in the document, can you please tell the jury what the defendant texted you?
Judge, I can object since it's a document, not an evidence. I don't know how she could read from it.
Your Honor, we already had a 104 hearing where
You want to move into evidence?
I can move them into evidence. I was going to do it at the end, but
Okay, I'll agree to that.
okay. So I have the other ones too. I can move into evidence. So the state will move it into evidence as well.
So, ladies and gentlemen, you're going to hear about these text messages. The statements of the defendant you can consider as statements. I'm going to give you an instruction later about statements of defendant electronically or if there's any oral ones. So I'll ask you to consider them at the end of the case in connection with that instruction. In addition, in terms of the statements of Ms. Micciolo, they're actually hearsay, but she's here testifying about it. So I'll allow them in for that reason. I concluded it wouldn't make much sense for me just to give you the defendant's statements or responses if you couldn't see the other half of the conversation. So in order to be able to give you a full picture, I'm allowing both Ms. Micciolo's messages and the defendant's alleged responses into evidence in order to give you that context to be able to analyze them. Thank you.
Thank you. Okay, so turning your attention then to S7 in particular at the top of the page at approximately 4:1 at, can you read the time for the jurors?
7:26.
Okay, and what did the defendant text you?
He said, "Where are you?"
And what did he text you next?
He said, "It'll be past 7:30 and I will take over and be with my son."
And what did he say after that?
"I have no idea where you are and you will not tell me on the phone. Why is that? You were past your time by the court order and I want to be there for my son."
Okay. And what was your response to that?
I said, "I am driving to Jersey Shore Medical Center. I'm doing what a caseworker for DCPMP told me to do."
Thank you. Now, Brianna, while you were at Community Medical Center, did you sign Corey out of the hospital?
Yes.
And can you tell the jurors why you did this?
Because I wanted to drive him myself to Jersey Shore Medical Center.
And why did you want to drive him yourself to Jersey Shore Medical Center?
Because I was already late and I didn't want to spend another 30 minutes waiting.
And what had the hospital offered at the time?
To transport Corey.
Now, while Corey was at Community Medical Center, was he physically examined?
Yes.
And what was Corey's condition at Community Medical Center?
He was fine.
Now, did Jersey Shore Medical Center have a pediatric abuse specialist on staff?
Yes.
And while all this was happening, did you speak to Barb, the DCP&P worker?
Yes.
Now, after you and Corey left Community Medical Center, where did you immediately go?
Jersey Shore Medical Center.
And what was Corey's physical condition while you were with Corey in the car?
Fine. He was just watching videos on my phone.
And what was Corey's demeanor?
Normal. Happy.
Now, approximately what time did you arrive at Jersey Shore Medical Center with Corey?
Around 8.
And did you speak to the doctor at Jersey Shore Medical Center?
Yes.
And did Corey speak to the doctor at Jersey Shore Medical Center?
Yes.
And what was Corey's demeanor while at Jersey Shore Medical Center?
He was okay. He was just a little tired because it was getting late.
And was Corey examined by a doctor at Jersey Shore Medical Center?
He was.
And what tests were performed on Corey at Jersey Shore Medical Center?
He had an x-ray and blood work.
And while Corey was at Jersey Shore Medical Center, was he seen by the pediatric abuse specialist?
I believe so.
Or is he seen by an emergency room doctor?
I think it was an emergency room doctor.
Now, while you were at Jersey Shore Medical Center on April 1st of 2021, did you have a telephone conversation with the defendant?
Yes.
And about what time did that conversation occur?
Around 8:30.
And can you tell us about the conversation you had with the defendant?
He called me and he asked me to leave the hospital with Corey, and I said I wouldn't. I want him to be checked out, and then he started just verbally attacking me and fighting with me.
And did the defendant know that you were at Jersey Shore Hospital with Corey?
Yes.
And can you tell us what happened at the hospital regarding your cell phone?
My phone died.
Now, at 11:43 p.m., did the defendant send you a text message asking you where you were?
Yes.
Your Honor, permission to approach? No, you're S8.
Yes. Ladies and gentlemen, I need to give you that instruction now. We're getting into a lot of statements allegedly made by Mr. Gregor. So some of these are written electronically, say by text message, and now we're talking about potentially an oral statement. So regarding statements of the defendant, there is for your consideration in this case various statements that the state claims were allegedly made by the defendant. Some recorded electronically, others orally. It is your function to determine whether or not each statement was actually made by the defendant, and if made, whether the statement or any portion of it is credible. With regard to any oral statements, as opposed to ones recorded electronically, there's an additional instruction. In your consideration whether or not an oral statement was actually made by the defendant, and if made, whether it is credible, you should receive, weigh, and consider this evidence with caution, based on the generally recognized risk of misunderstanding by the hearer or the ability of the hearer to recall accurately the words used by the defendant. The specific words used and the ability to remember them are important to a correct understanding of any oral communication, because the presence or absence or change of a single word may substantially change the true meaning of even the shortest sentence. Therefore, with regard to oral statements, you should receive, weigh, and consider such evidence with caution. With regard to both oral and recorded statements, written or electronically, again, in considering whether or not a statement is credible, you should take into consideration the circumstances and facts as to how the statement was made, as well as any other evidence in this case. If, after your consideration of all these factors, you determine that any such statement was not actually made, or that the statement was not credible, then you must disregard the statement completely. If you find that any such statement was made, or that part or all of the statement is credible, you may give what weight you think appropriate to the portion of the statement you find to be truthful and credible. And again, at the end of the case, I'll give you those instructions, and I'll probably break those down into two separate ones for oral as well as written, but at this time, since we're on that issue, I wanted to address that. Ms. Lento, it's close to the lunch break. Do you want to just go through this one exhibit and then we'll take a break, or you want to stop now?
Judge, I do have a lot more, so I was hoping maybe we could stop now and kind of give everyone a break and return after one.
Thank you. Any objection to that, Mr. Gallucci? None. All right, so ladies and gentlemen, we'll take a 1 hour break for lunch. If you could come back to jury assembly, remember always report to jury assembly, especially today when we have a lot of people in the hallway and in the courthouse. Again, you can go to lunch together if you like, or you go to lunch individually. You can talk. You just please don't discuss the case, any of the testimony you've heard, any of the charges. Don't let anyone else contact you while you're on the court property. Please keep your jury badges identified and exposed. I've made it clear to everyone no one should come up to you if you're wearing those juror badges. Again, you can't make any conclusions until you've heard all the evidence, heard the summations of the attorneys, and received my instructions as to the law. So about 1:30 or so, if you're running a couple minutes late, that's fine. We'll obviously wait for you back at jury assembly as always, and we'll come get you. Thanks so much.
Your Honor, do you want to excuse the witness? He's under sequestration.
And began to discuss with me certain issues that we alluded to on the record earlier this morning. Mr. Gallucci evidently produced a transcript from the Monroe Municipal Court showing that the witness, Ms. Micciolo, evidently pled guilty to a municipal ordinance offense as a result of a citizen complaint rather than a police-initiated complaint. The municipal ordinance is not a crime or offense of the Code of Criminal Justice, but it's a local law. Defense seeks to utilize that in cross-examination of Ms. Micciolo. Mr. Gallucci, would you like to amplify that on the record, please?
Your Honor, I do understand that it's not a crime, and that I would not be allowed to ask her if she pled guilty in a court. I do understand that. But I would like to get into the underlying facts that she recited on the record about what they did to the Gregor house. It was actually on 3 separate occasions that her and 2 or 3 other people went to the Gregor house and committed acts of vandalism, throwing rocks, throwing dead fish, and whatever.
You're referring to Mr. Gregor's parents' house?
Yes, David and Darren's house. And there was a complaint made. I believe that she went to court. I believe her and her mother pled guilty. And they actually had to pay restitution in the amount of, I think, $1,200 or $1,300. So I think that goes right to our credibility. It's not the normal person that goes to somebody's house and throws rocks and dead fish at it. And I think that the jury should hear that she's doing that. This is conduct that she's doing, and this is in August of 2021.
Charged in August of 2021, and you indicated to me that the transcript is June of 2022?
Yes.
All right, you also raised a post on the Justice for Corey site that you attribute to the current witness, Ms. Micciolo.
Yeah, Judge, so we have a number of posts from the Justice for Corey page, and I understand a lot of them I could use for impeachment if I could prove that they were done by Ms. Micciolo. But one of them that we do have now is a post by presumably her, Bree Micciolo, on the Justice for Corey page as the administrator, I don't want to say on the record what it says, but it's something posted by her that's not quite flattering to anybody. So, and I think it goes right to him, and it goes right to, you know, what the justice for Corey Page, like I'm hoping for, was made not for justice for Corey, but for terrorism of the Gregor family. That's what it was created for. So, I think I should be allowed to get into it. I have a number of other posts from the justice stand. I'll make a determination then, and I will not do it permission.
Well, in terms of attributing to her, I don't have a problem. You show her a document and say, do you recognize this? Right, do you recognize this? Is this your screen name? Did you post it before disclosing the contents of the document? I think you have to authenticate it that way if we're going to do that. But let's hear from the state first as to the municipal court issue, and then these one or more posts from Justice for Corey Page.
So Judge, with the municipal court issue, it's my understanding that it was a citizen's complaint. It was a guilty plea to an ordinance, not a felony conviction in a superior court, and it postdated by months the death of Corey. And so the only relevant purpose to use something like that would be flight, impeach her credibility. She hasn't lied about anything. This is not a time frame that's relevant to the crimes. The crimes are March 20th, 2021 and April 2nd, 2021. So something that she's alleged to have done months later, I just don't see how that goes to flight or anything else that she's here testifying about today. It's just not relevant to the crimes. And I understand that counsel is arguing that it's kind of the culmination of all of this conduct that's happening, but if they want to proffer something that's happening on April 2nd, then that's a different argument. But this is not it. This is not the piece of evidence. And with regard to the posts on social media, first of all, it's my understanding that Justice for Corey is a closed site. So I don't know how they're terrorizing the Gregor family or anybody else with this closed group on Facebook that's not open to the public. Additionally, I saw the post for the first time in court today when Mr. Gallucci showed me. I do not know what other posts he intends on using, but they may be from a closed group that we were not provided in discovery as well. Those posts, the one at least that I saw, and that's one, it's not dated, and it has absolutely nothing to do with any relevant purpose in this case. It has nothing to do with how Corey died and who killed him. And her credibility is not at issue insofar as those messages. So the state would object not just to what happened in municipal court, and not just to the one Justice for Corey post that counsel brought to our attention, but any of those posts that haven't been shown to us yet that he might approach the witness with.
All right, can we mark those as defense exhibits for identification only so we have some record of what you're referring to expressly?
Mark Olin?
Well, I was referring to the one transcript and this one post, right? You know, I need to protect the record for appeal as what the specific document is I'm deciding about. So D1 is that transcript?
Yes, Judge. D2 will be the justice for Corey.
May I look at them, please? D1 for identification is a transcript from the Monroe Township Municipal Court for a hearing on June 7, 2022 in front of the municipal judge. The transcript is entitled David Gregor versus Brianna Micciolo, Rebecca Micciolo, and two other individuals. Since I don't know their involvement, I'll use their initials, KD and DC. Both sides were represented by counsel. a reference to restitution of $1,200. On page 14, there's a reference to Rebecca Micciolo being charged, but she's not currently testifying. And then Miss Brianna Micciolo is addressed by the court, and amended to a township ordinance. The judge indicated satisfied there is a sufficient factual basis for that plea, imposed a fine of $150 and $33 in court costs. And the restitution, the judge indicates he puts the burden on Brianna to pay the restitution, but if the mother wants to assist her to pay that, that's satisfactory.
If I could just note on page 13, it references that there was a complaint against Carolyn Gregor that was pending, that as a result of this global resolution of everyone was dismissed.
Thank you. So first, I find that under Evidence Rule 608, it is not a criminal conviction that could be used to attack or impeach the credibility of the witness. However, the underlying facts are arguably other acts or wrongs committed by the witness. The standard for the admissibility of such evidence, say, against the defendant is rather high. That's under Evidence Rule 404B. However, the standard for the admissibility of prior wrongs or acts when sought to be used defensively is a much lesser standard. And the court is required to apply that lesser or relaxed standard for the admission of defense evidence of prior activity by a witness. See, for instance, State v. Weaver, 219 New Jersey 131 at 150, a 2014 New Jersey Supreme Court case. That admissibility of other crimes evidence or other wrongs evidence used defensively is governed by the simple relevant analysis, Evidence Rule 401. The standard is, quote, simply relevance to guilt or innocence, close quote. That's the Weaver case at page 150. As we all know, evidence is relevant. It has a tendency and reason to prove or disprove any fact of consequence to the determination of the action. See also State v. Williams, 190 New Jersey 114 at pages 122 and 23, a 2007 New Jersey Supreme Court case. It is well established that a defendant may use similar other crimes or wrongs evidence defensively if in reason it tends, either alone or with other evidence, to negate his guilt of the crime with which he is charged. State v. Garofalo, 76 New Jersey 445 at 453, a 1978 case. In addition, the court must also undertake a Rule 403 analysis. Essentially, the question there, if the evidence is relevant, its relevance must be balanced against counter considerations of undue consumption of time, confusion of the issues, or misleading the jury. So here, with respect to Exhibit D1, although a adjudication of the municipal ordinance is not itself admissible, I find that the admissions by Ms. Brianna Micciolo of some other bad acts are subjects that could be, that defense counsel could cross-examine her on. They do have a tendency and reason to relate to her credibility. For instance, the case is one heavily of credibility about the condition of Corey on late in the day on April 1st and early in the morning on April 2nd when his mother drops him off with his father, and then it's admitted that he's with his father all day. The question is, do his injuries or conditions which ultimately cause his death result in his father's care, or did the father receive the child that way? The only three people involved in that are the decedent, sadly, the defendant and this witness. So her credibility is something that the defendant has a Sixth Amendment right to be able to address. So I find, under the relaxed standard, that these other acts, for which she made some admissions of in the Monroe Township transcript, are admissible as defensive use of other bad acts against a witness. Exhibit D2 is a little more problematic. It's a post from the Justice Recorey site. Presumably it's the same person as the witness here. It says, Bree Micciolo, quote, how I'm feeling today, close quote. It contains a photograph of Mr. Gallucci side by side of a separate photograph of Mr. Gregor. Below that, there's some emojis followed by, quote, fuck you both very much, close quote. Assuming this is a post that is in fact made by this witness, the court finds that it has very little relevancy, but assuming for the sake of argument, it has some relevance in that the witness has a hatred for the defendant. That hatred could be explained by her belief that the defendant's guilty of the child's murder, and then obviously she transfers that hatred to his defense attorney, which is not particularly unusual that defense attorneys have to go through that. So assuming it has some relevance, the court finds, first of all, any of her feelings or hatred for the defendant will likely otherwise certainly come out if they exist. And secondly, I find that the probative value of that evidence is substantially outweighed by the risk of undue prejudice, confusion of the issues, and misleading the jury. It's a rather vulgar statement. It's not something that impeaches a factual comment the witness made, either here on the stand or in any type of statements. It probably is more of an expression of anguish as to the child's death and her belief that representing someone accused of that is somehow improper, although we all know it's not. The defendant has a constitutional right to counsel. So I find that D2 has little or no probative value. If it has any probative value, it's substantially outweighed by the risk of prejudice, confusion, and misleading the jury, directing them away from the issues in the case to some vulgar statement that a mother made. On balance, someone lost a child. It's not unusual to respond in an emotionally upset manner or make a statement that shows emotional upset. In contrast, if there are other posts by Ms. Micciolo which are more of a factual nature about something she recalled, something she saw, something she heard, which impeaches what she said in court or in a prior recorded statement, say, given to the state, that would be a different story. And so my ruling is without prejudice to any further posts that Mr. Gallucci may raise to impeach the witness in the event it's a factual statement as opposed to this expression of anguish and opinion. So I'll give those exhibits back to Mr. Gallucci. Thank you.
Thank you.
All right, we've kept that jury waiting long enough. Anything before you bring the jury back over?
Just one other thing which we discussed briefly was the information from the Celebrate, which is a conversation from Brianna to Dustin Boardran, which is on April 2nd, 2021. On that date, and by the way, she just testified on direct about this. They're talking about how Corey was. They're talking about he was okay. He wasn't upset about going back. No. That's good. I want to be in my house by myself for a little while. But then she says something that's very interesting, and this is at 3:49:08 p.m. She asked Justin to bring her a bump. She then says to him again, well, can I come and buy one from you? And then she says, I'm going to go and get it myself. I just don't want that much. Dustin responds, what do you want me to do? She says, which one? I just asked you to bring me a bump. And he said, okay. So
What date is that?
this is the day, 4/2/21, the day of death. This is starts at 2:54, which I think she started to testify about what was going on that day, but this is the conversation she's currently having with her, I think it was her boyfriend at the time on 4/2/21, asking him for drugs. She just testified that she's been clean. So I think this goes right to her credibility, not only right to her credibility, but shows Corey's state of mind, that he had no problem going to his father's house, and that instead of her being concerned about him going to her father's house, she's looking for her boyfriend or drug dealer to bring her cocaine. So I think that's pretty relevant.
Your Honor, so first of all, right, on 4/2/21 at 2:54, Corey at this point is not with his mother. At this point, Corey has already been dropped off. What counsel is referring to, it is hearsay. This Dustin that he's referring to, it's not my understanding that the state's going to be calling him as a witness, nor would, I don't believe the defense attorney would be calling him as a witness. My understanding of the testimony is that she was clean, meaning from when Corey passed away. At this point in time, Corey did not pass away. So I don't know if that conversation, I guess the defense attorney is going to argue it infers that she did drugs later that day. But again, I don't see the relevance in that, because at that point in time, she had already given Corey to his father, and Corey was no longer in her control. And she did testify that she never did drugs in front of Corey. And my understanding of it as well is since Corey died, and this would have been before Corey died. So,
Judge, I want that D3 if you'd like to take a look at it.
Please. However, the witness just testified that she had a conversation with Mr. Gregor when he arrived at the hospital, or when he was about to go to the hospital, and asked for the insurance card for the child, and that was, according to the witness's testimony, after 3 p.m. So the witness was seeking to use drugs at or very close in time to that conversation. Is clearly relevant to her ability to recall, recollect, and relate. One of the factors I just instructed the jury on how to judge the credibility of witnesses. So if Ms. Micciolo was looking to purchase drugs at that point in time, then that would be something relevant. The only thing is, Mr. Bellucci, you can't give your opinion what bump means. You have to admit that, or you have to otherwise find some admissible way of determining what that is.
Your Honor, it is the state's understanding, though, that that happened after the conversation, from our understanding of the timeline.
But she testified that the call was at 3-something.
Yeah, it's at
Well, we didn't get, I don't think, but it's at 3:10,
And that's consistent with the call log.
which be consistent with the call log.
Judge, the conversation starts at 2:54 between her and Dustin.
Right, and she testified her conversation with Mr. Gregor was after this text message marked as D3.
Yes.
She said it was 3-something.
I know, I don't know, I need to look at the text message about the bump, that's what,
Thank you.
the time bump, thank you.
After.
It's after, Judge, it's at 3:49,
No, 3:18.
3:18.
Hold on.
Oh, maybe I'm wrong,
Hold on.
take it back.
3:49, that's the text message.
3:49 is the text message, Your Honor.
Thank you. She sends her insurance card at 3:30. S.
The witness is seeking to obtain and use some kind of illegal narcotics at or around the same time she's talking to Mr. Gregor, whether it be immediately before or immediately after. That's relevant to her ability to recall, recollect, and relate. It's also relevant to her testimony here that she's been clean and she's not using drugs anymore. It also relates to a lot of things about the care and custody of that child between 2 people on the morning of April 2nd, 2021.
Okay, thank you.
Defensive use of bad acts. And I find it's relevant and it's not so unduly prejudicial. You've already disclosed, she's already disclosed to the jury that she has certain substance abuse in the past, and it's brought out on direct examination. So I find it's appropriate in this one.
Thank you.
Sure.
Me.
Your Honor, we're going to get the jury. Good?
Please, yes. Please be seated, everyone. Thank you. Ladies and gentlemen, thank you so much for your patience. I apologize for the delays. I promise you, I'm not just having you sit over there for no reason. There's always things that come up, always things that have to be addressed. It happens in every trial, so we appreciate your patience, and I thank you for that, and I thank you for your understanding. We're going to continue with Ms. Micciolo's testimony. We'll bring her back in, continue on the direct examination by the state. Thank you, ma'am. Please watch your step and have a seat. Ms. Lento.
Thank you, Judge. So, Brianna, at approximately 11:43 p.m., while you were at Jersey Shore Medical Center, did the defendant send you a text message asking where you were?
Yes.
Your Honor, permission to approach the witness?
Yes, absolutely.
You want to see it? Good. Hey, Brianna, I'm now showing you what's been marked S8 for identification purposes. And do you recognize that?
Yes.
And those are text messages from your phone?
Yes.
And you're familiar with those text messages?
I am.
Your Honor, permission to enter into evidence and publish?
Certainly. So that's S8.
S8.
Any objection?
None.
S8 in evidence.
Okay, now calling your attention to the first message. Can you tell the jurors what the defendant said to you and what time that this occurred?
At 11:43, the defendant said, "Why are you now ignoring me?"
And can you tell the jurors what your response was?
I said, "My phone died and I just got a charger. I'm at the hospital because DCPMP spoke to doctors and they told me to come here. You could have came here from the beginning. You said no, drop him off. We could have taken turns the whole time. I'm not doing anything wrong. Stay up and I'll drop him off as soon as we're done."
Can you please turn the page? Now calling your attention, can you please continue to read the first two messages with the dates and the time as well to the jury?
On 4/1/21 at 11:52, I said, "You're not going to stay awake." And then on 4/2/21 at 12:48, I said, "How are you going to go to court and say anything about me keeping him? You won't even stay up for me to drop him off, and I'm offering now."
Okay. Thank you. Now, after those text messages, when is the next time you heard from the defendant?
The next morning, or that morning.
Now, was Corey released from Jersey Shore Medical Center?
Yes.
And can you tell the jurors about his blood work?
It was all normal.
And what about in regard to any x-rays or scans?
That was normal as well.
And was that text message at approximately 11:43, was that the last time that you had contact with the defendant that evening?
Yes.
And can you tell the jurors why would you try to bring Corey back to his father's house from Jersey Shore Medical Center?
So I didn't break the court order.
Now, after you left Jersey Shore with Corey, can you tell the jurors where you went?
I went to my house in Englishtown.
And how long of a ride was it?
About 45 minutes.
And what was Corey's demeanor in the car ride?
He was tired. It was 1 a.m. and he fell asleep in the car.
And about what time did you then arrive at your home?
I want to say like around 1:30.
Okay. And when you got to your house, can you tell us who was awake?
No one.
And when you got to your house, where did you and Corey immediately go?
We went to my bedroom
And where was your bedroom located in the house?
in the basement.
And where did you and Corey sleep that night?
We slept in my bed.
And while you slept in bed with Corey, what was his physical condition?
He was okay.
And can you tell the jurors what Corey's demeanor was while you slept in bed with him?
Normal.
And can you tell the jurors why you slept in bed with Corey that night?
It was just easier because it was really late and I just didn't want to get him ready in his room.
What time did you and Corey wake up the next morning?
Around 7:30.
And when Corey woke up, did you dress him?
Yes.
And where did you dress Corey?
In my room.
And what did you dress Corey in?
I put him in a sweatshirt, jeans, and sneakers.
And what about his underwear?
They were blue underwear.
And what was the condition of the clothes that you dressed Corey in?
They were clean.
And after you dressed Corey, where did the two of you then go?
We ate breakfast in the kitchen.
And when you went upstairs to eat breakfast in the kitchen, who was there?
My mom and her boyfriend, Richie.
And did Corey have breakfast?
Yes,
And did he eat?
he did.
And do you remember what he ate?
He ate a bagel and a Gregor.
And were you with Corey the entire time that he was eating breakfast?
Yes.
And can you tell the jurors what was Corey's physical condition in the morning when he was eating breakfast?
He was okay.
And what about his demeanor?
Normal. He was fine.
Now, that morning of the 2nd at approximately 6:48 a.m., did you receive a text message from the defendant?
Yes.
Your Honor, permission to approach the witness?
Yes.
It's the rest of them. You saw them already? Okay. Grant, I'm now showing what's been marked S8, which has already been admitted to evidence. Turning your attention to the text message conversation, can you please tell the jurors what the defendant said, starting with that particular message, and can you let the jurors know the time and the date as well?
Okay. On 4/2/21 at 6:46 a.m., he said, "I'm going to court because you decided to go when you had 7 days last night, and by your text, you were still there at 12:50 at night. You are a detriment to Corey's health, and I will be going to court today about it."
And can you read the next message from the defendant as well?
Yes, 6:46. He said, "By the way, school starts at 8:30, so have him back before 8:30.
Brianna, after Corey had breakfast, where did you drive to?
To the defendant's house.
And when you were driving to the defendant's house in Barnegat, where was Corey seated in the car?
He was in the back seat.
And how long of it was a drive to Barnegat?
About an hour.
And what was Corey doing while you were driving to Barnegat with him in the car?
He was watching YouTube on my phone.
And what was Corey's demeanor in the car?
He was okay.
Now, while you were driving Corey to Barnegat, did you receive a text message from the defendant?
I did.
Your Honor, permission to approach?
Yes.
Grant, I'm now showing you what has been marked S9 for identification purposes. Do you recognize this?
Yes,
And you're familiar with that?
I am.
And is that a text message that you received from the defendant, which was located on your phone?
Yes.
And can you please tell the jurors what the defendant texted you, including the date and the time of the text message?
Yes, on 4/2/21 at 8:37 a.m., he said, I mean, considering you did kidnap my son for an entire day and night, the minimum that is happening is an entire day and night is going to be removed from your next visit maximum. Hopefully the courts will agree with my application this morning and you will lose all rights.
Thank you. Now, when you got to the defendant's apartment complex to drop off Corey, where did you park?
In front of the defendant's home.
And about what time did you get to the apartment complex to drop off Corey that morning?
Around 9 a.m.
And when you got there, where was the defendant's car?
I'm not sure. It wasn't there.
And did you text the defendant asking where he was?
Yes.
And what did the defendant say to you in regard to where he was?
He said he was home.
And before Corey had left the car, did you provide Corey with a piece of paper?
I did.
And what did you give Corey?
It was a paper from the hospital that had information so the defendant could look at his records.
And why did you do that?
I was just being nice.
And did you speak to Corey in the car before you sent him into the defendant's home?
I did.
And was that the last time that you spoke to Corey?
It was.
Did Corey exit your car?
He did.
And can you tell the jurors where Corey walked?
He walked inside defendant's home.
And how was Corey walking when he went to the defendant's apartment?
Fine.
And did Corey open the apartment door of
Yeah.
the defendant's apartment?
Yes.
Now, continuing on in the morning of April 2nd of 2021, were you and the defendant arguing?
Yes.
I have permission to approach S11. And I'm now showing you what's been marked S11 for identification purposes. And again, are those text messages that were contained in your phone? And you're familiar with those messages?
I am.
Your Honor, at this time, the state would move to publish and into evidence of S11.
No objection.
S11 evidence.
So, Brianna, starting with the top message, can you please tell the jury about your conversation with the defendant?
Yes, at 9:48 a.m., I said, "Stop being so cocky. If I were you, I definitely wouldn't be."
And then what did the defendant respond?
He said, "Yes, I am a ludicrous charge by you that when you went to court yesterday was completely thrown out and disregarded."
And can you continue with his next message?
He said, "Shows how much evidence there is, doesn't it? You're going to be in for a rude awakening today."
So, Brianna, what is the next time that you heard from the defendant on April 2nd of 2021?
Around 3:30.
And did you speak to the defendant on the telephone?
Yes.
And at 3:30 on April 2nd, what did the defendant tell you about Corey?
He said he was lethargic. His legs were hurting. He was sleeping all day, and he was throwing up and just didn't feel good. And then he told me to send Corey's insurance card to him.
And did you send the defendant Corey's insurance card?
I did.
And did the defendant say anything about taking Corey to the hospital?
Yes.
And did the defendant tell you what hospital he was taking Corey to?
No.
Was that the last time that you had spoken to the defendant on that day?
Yes.
And did you learn what hospital Corey was taken to?
Yes.
After the phone conversation, did you know at that time what hospital Corey was taken to?
No.
And at that time, what did you do?
I started calling the hospitals to see if Corey was there. I also called my local police department to kind of report Corey as like I don't know where he is, and he's not feeling good. He's sick.
And about 6 o'clock that day on the 2nd, did the police come to your home?
Yes.
And did you learn at that time that Corey had passed?
I did.
Now, on that same day that Corey passed away, did you go to the police station and provide a statement?
I did.
And whom did you speak to?
Detective Dennis Mitchell.
And what did you give to Detective Mitchell at the police station?
My cell phone.
And did you voluntarily provide that to the detective?
Yes.
And did you also allow officers to photograph your home in Englishtown?
Yes.
The photos. Your Honor, permission to
Please.
approach. Your Honor, I'm now showing you what's been marked S21, S20, S23, S19, S35, S32, S33, and S24, and S34, and also S24. Now calling your attention to S22, are you familiar with the area
Yes.
depicted there? And can you tell the jurors what that is?
It's a TV stand in my bedroom.
And in your hand you're holding a what?
Photograph?
And you're familiar with that because it's in your bedroom?
Correct.
I'm now showing you what's been marked S23 for identification purposes. And can you tell the jurors what that is?
This is my bedroom.
Okay, and what you're holding is what, a photograph?
Yes.
And you're familiar with the area depicted in that photograph?
Yes.
Okay, I'm now showing you what's been marked S20. Is this another photograph?
Yes.
Okay, and are you familiar with the area depicted in that photograph?
Yes.
And what is that?
It's the entrance to my house.
Okay, I'm now showing you what's been marked S21. Are you familiar with that photograph?
Yes.
And what is that a picture of?
It's a hallway to my bedroom.
Okay, so you're familiar with what's depicted in that photograph. I'm now going to show you what has been marked S19. Are you familiar with the area depicted in that photograph?
Yes.
And can you tell the jurors what that is a photograph of?
It's a photo of the defendant's home.
And you've been to that location before.
Yes.
I'm now showing you what has been marked S24. And are you familiar as to what's depicted in that photograph?
Yes.
And what's depicted in that photograph?
It's the paper I gave Corey to go inside with.
Okay, so you're familiar with that paper because it was under your control and then you gave it to Corey.
Yes.
I'm now showing you what's been marked S34 for identification purposes. And do you recognize that?
Yes.
And what is that a photograph of?
Corey's underwear.
And is that the underwear that you put on Corey when you drove him to the defendant's house on April 2nd of 2021?
Yes.
And in regard to that photograph, is what's depicted in that photo the condition of the underwear that you sent Corey with that day in going to the home?
No.
And I'm now showing you what's been marked S33, and are you familiar with that?
Yes.
And what is that a photograph of?
Corey's underwear.
And again, is the underwear in the same condition as to when you sent Corey in that underwear to the defendant's home?
No.
I'm now showing you what's been marked S32 for identification purposes. And again, is that the underwear that you sent Corey in, a photo of that on April 2nd of 2021?
No.
That's not the underwear?
Oh, yes. I'm sorry.
Okay. And is the condition the same?
No.
Okay. And I'm now showing you what's marked S35 for identification purposes. And can you tell the jurors what that is?
It's Corey's underwear.
And again, you're familiar with that? And that's the underwear that you sent him in?
Yes.
And was that the condition it was when you sent him in that
No.
underwear? Your Honor, the state would ask for permission to publish and move into evidence the photos.
Your Honor, can I just see S22 and 23?
Sure. Ms. Lento, I'd like you to just put them in order so we can go through them in numerical order
Sure.
and we enter them into evidence. And if you could show 22 and 23 to Mr. Wood.
I'm giving it to you. She's giving it to you. 22? 23?
No objection?
Okay.
All right, so if I kept those numbers correct, it would be, let me know if I'm right, Ms. Lento, S19 through S24 and S32 through S35, is that right?
Yes, Judge.
All right, so S19 through and including S24 in evidence, S32 through and including S35 in evidence.
Yes.
Thank you.
Your Honor, at this point, we would ask for permission to publish the photos to the jury.
Grant.
Thank you. Okay, Brianna, so you're familiar with that location.
Yes.
And can you tell the jurors what that location is?
That's the defendant's home.
And the day that you dropped Corey off back to his father on April 2nd, can you show the jurors where you parked that day using the photograph of S19, which is now before the jury?
Yeah, it was all the way to the right, the second spot to the left.
We could go to the next picture. Okay, I'm now showing you S20, which has been published to the jury. And can you tell the jurors what that is a picture of?
That's the entrance of my home.
So when you came home with Corey around 1-something on April 2nd, is that where you and Corey entered the home?
Yes.
And what area in your home does that depict?
The entrance and the living rooms to the left, and my bedroom doors to the right after the hallway.
We can move to S21, please. Okay, now you can see S21, which has been published to the jury. And can you tell the jurors what is depicted in that photograph?
That's the stairs and the hallway to my bedroom.
S22, please. And can you tell the jurors what that is?
That's a TV stand in my bedroom.
Okay, and why is that TV stand there in your bedroom?
To hold the TV.
And is that where you would generally sleep downstairs?
Yes.
Okay. If we could then go to S23. And can you tell the jurors what that is a picture of?
My bedroom.
Okay. Now, the night that you brought Corey back to your home in Englishtown on April 2nd at 1-something in the morning, can you show the jury where you and Corey slept?
Yes, it was the bed on the left.
Next picture, please. I'm now showing you what's been marked S24, which has been published to the jury. And can you tell the jurors what that is a photograph of?
That's the paper the hospital gave me that I gave Corey to give to the defendant.
And I'm now showing you, if we could move to the next photo, S32. And can you tell the jurors what S32, the photograph, shows?
They're Corey's underwear.
Now, is that the underwear that you sent Corey in to his defendant's home on April 2nd of 2021?
Yes.
And if we could move to the next picture, please. I'm now showing you what's been marked S33. Is that the underwear that you sent Corey in to the defendant's home on April 2nd?
Yes.
Now, when you sent Corey in this underwear, was that the condition of the underwear?
No.
And what was the condition of the underwear when you sent Corey to the home?
They were clean.
And can we now go to S34? And again, is this a photo of the underwear that you dressed Corey in when you brought him to the defendant's home on April 2nd?
Yes.
And is that the condition of the underwear?
No.
S35. And again, the underwear on S35 as the photograph, was that the condition of the underwear that you sent Corey in when you brought him to the defendant's home?
No,
And what was the condition of the underwear that you sent?
they were clean.
S36? Oh, no S36, Judge.
All right, we didn't get to that yet.
Yep. You wanna turn the flash drive? Which one is the flash drive?
This one
Is the voice recording, and this one is the gym. Okay. The voice recording. I'm now going to show you what's been marked S15A for identification purposes. And do you recognize that?
Yes,
And what is that?
it's a flash drive.
And are you familiar as to what's contained on that flash drive?
Yes,
And have you previously viewed what has been contained upon that flash drive?
yes,
Okay. And can you tell the jurors what is contained in S15A?
it's a conversation between me and my son.
And when did this conversation occur?
On April 2nd.
And are you speaking to Corey in this conversation?
Yes,
Your Honor, at this time, the state would ask to move S15A into evidence and publish to the jury.
S15A and evidence.
Oh, and also, too, the transcript, yeah. If I may approach the transcript.
Yes, so ladies and gentlemen, S15A is the actual electronic exhibit you're going to see. S15B is a transcript of that exhibit. It's prepared by the prosecutor's office. The transcript is not evidence itself. Instead, it's an aid for you to follow along on what is allegedly said in the video. If you find the transcript is inaccurate and you believe you hear something else or something slightly different or something altogether different on the video, then your recollection, your judgment of what's on the video controls. It's merely an aid to follow along. And with that understanding, Sergeant Dugan's going to pass it out to you.
While she's passing it out right now, I'm now going to show you what's been marked S15B. And is that the transcript of the audio recording?
yes,
And you reviewed this as well before you came to court today?
yes.
And Your Honor, permission to publish to the jury?
Yes, granted.
Did he ask me? Well, he's your other parent, so it's his right. He needs to see it because you went to the doctor, and I just want to make sure he sees that. Okay?
All right, ladies and gentlemen, it never fails that we have a technological problem. We did this outside your presence, and it worked fine. So there's actually some video portion of this, which Ms. Strome is going to try and... Looks like, is the TV off? I think that's the problem, right? Is the screen off? There we go.
I don't think the TV's off, but it's not showing my desktop because there's an icon on my desktop. It wasn't showing that PowerPoint was
Right.
open before, so something's not working with regard to the connection because everything's working on my computer. And this is not an exact copy of my computer right now.
Your Honor, I believe the IT guy is standing by in here. I'll go.
Please, yeah. All right, I'm told he's on the way, sir. Thank you for your patience. Hi, Dan, the video from earlier is not We heard the audio, but not the video playing on the screen.
It's also just there. Do you want me to get up?
It's a short video. You want to just stay and make sure it works? It's only a couple seconds.
Your Honor, just permission to publish the video.
Go ahead, please.
You don't have sound from the beginning, Judge, for some reason.
Did he ask me? Well, he's your other parent, so it's his right. He needs to see it because you went to the doctor, and I just want to make sure he sees that. Okay? I'm not sure where he is. Yeah, he's inside. I don't know why the car's not here. That's strange.
Okay, Brianna, so in regard to the video recording that you just saw and listened to, is that your voice depicted on the recording?
Yes.
And who is the other voice depicted on the recording?
My son Corey.
And obviously you're familiar with Corey's voice.
Yes.
And the conversation that you had with Corey on April 2nd of 2021, a little past 9 a.m. that morning, does that accurately depict the conversation that you had with him, what was shown in this video?
Yes.
Now, did you know that you were recording this conversation at the time?
No.
And how did it come to be that this conversation that you had with Corey was recorded?
Detective Dennis Mitchell from the prosecutor's office called me and asked me about it.
Okay. And Detective Mitchell had your cellular phone?
Yes.
Okay. And was this video recorded on your cellular phone?
Yes.
And did you purposely record this on your cellular phone?
No.
And how did it come to be that the recording existed from your cellular phone?
I must have accidentally took the video.
Your Honor, permission to approach the witness?
Yes.
Yes, ABCD.
Yes, it's been on.
Mario. Flash drive. Video. Jen.
Okay, I'm now showing you what has been marked S18 for identification purposes. And can you tell the jurors what S18 is?
It's a flash drive.
And are you familiar as to the contents which are contained on this flash drive?
Yes.
And did you review the contents of this flash drive before you came to court today?
Yes.
Now, contained within this flash drive is SA. And is SA a surveillance video from the Atlantic Heights apartment complex in Barnegat from March 20th of 2021?
Yes.
and you are familiar with that location as to what is contained on S18A.
Yes.
And you've been to that location before.
Yes.
And you're also familiar with who is depicted on that video, correct?
Yes.
And in regard to the A video, you are actually present on the video, correct?
Yes.
And you are familiar with the other parties as well.
Yes.
I'm now going to draw your attention to S18, what would be B, C, and D. And those are also surveillance videos from the Atlantic Heights apartment complex gym, correct?
Yes.
And you have reviewed those videos before you came to court today, correct?
Yes.
And you are familiar with the location which is depicted on B, C, and D.
Yes.
And you're also familiar with the parties who are located on those surveillance videos.
Yes.
Your Honor, at this time, the state would move into evidence, S18, A, B, C, and D of S18.
No objection.
Permission.
S18, A, B, C, and D.
Thank you. And permission to publish, Your Honor, starting with A.
Yes.
Okay, Brianna. In regard to video A, there is a car located on that surveillance video.
Yes.
And whose car was that?
That's my car.
And there was also an adult male located on the surveillance video. And can you tell the jury who that was?
The defendant.
And there was also a child located on the surveillance video. Can you tell the jury who that is?
My son Corey.
Does that video accurately depict when you dropped Corey off to his father's apartment complex gym on March 20th, 2021 at approximately 4:15 p.m.?
Yes.
Now, there was a timestamp located on the video, correct?
Correct.
And is that accurate within an approximate reasonable time?
Yes.
Permission to publish videos B, C, and D, Your Honor.
Granted.
Thank you.
Sorry, let's start at the beginning.
going to move to the next video, which would be S18C for purposes of the record.
Very good.
Your Honor, permission to publish video D, please. Now, Brianna, who is the child located in that video?
That's Corey.
And how old was Corey in that video?
He was 6.
And who was the adult male located in that video?
The defendant.
And again, you're familiar with that area.
Yes.
Now, when was the first time that you ever saw that video?
A few weeks ago.
And have you ever had possession of that video?
No.
Your Honor, there's no further questions for the witness at this time.
Thank you. Mr. Galucci.
How are you, Ms. Micciolo?
I'm okay. How are you?
You need a second?
I'm okay.
Are you sure?
Yeah.
So, when was Corey born?
May 1st, 2014.
And where did he live when he was born?
With me, Monroe Township.
Okay. And who lived in the house with you?
My family, my parents, my sister.
And how long did he live in Monroe Township?
A few months.
And did there come a time when you guys moved from Monroe Township
Yes, we moved to Florida.
to Florida? And how long were you in Florida?
A few years.
Okay. And who lived with you in Florida?
My parents and my sister.
Okay. So it was just the 4 of you and Corey.
I think my brother lived with us at the time too.
And then there came a time you moved back to Jersey, or did you move to Pennsylvania?
I was in New Jersey.
Okay. So you moved from New Jersey to Florida, from Florida back to New Jersey.
I did.
And when did you move back to New Jersey?
Maybe 2017.
And how old was Corey in 2017?
3 years old?
Then it comes a time when I believe it was either you or your mother make an application for child support from Christopher, am I right?
Around there.
Around the time you moved back from Florida to New Jersey?
Yes.
And was it you or your mother that made that application?
It was my mother.
And prior to that, how were you supporting Corey?
Through my parents.
And there came a time where they didn't want to support him anymore?
Objection. Hearsay.
Oh,
Sustain.
yeah.
Thank you.
Sustain.
So there came a time where your mother decided that she wanted to seek paternity of who this child is to get child support.
No.
So how did it come back?
I applied to get food stamps and health insurance and, assistance from the government, and they made us name the defendant as the father, and they ordered him to get a DNA test.
Okay. And then you got a DNA test, right?
Correct.
And then you moved at some point back to New Jersey.
I guess so.
So, did he come to Jersey?
He did.
Okay, so it's not a guess, right?
Yeah.
Okay.
Right.
So he moved to New Jersey.
He did.
But when he moved to New Jersey, he not only paid child support, but he had custody along with you and your mother, am I right?
He had visitation in the beginning, yeah.
Okay. And the visitation would be at your house and at his parents' house, I guess, in Monroe?
Yeah. Yeah, Corey would go to his parents after school.
And things were fine, right?
I wouldn't say fine.
Okay.
No.
Tell me why.
I think it was maybe the first or second visit, Corey came home with a busted lip. Yes,
And you made a complaint about that,
I
didn't you?
did.
Okay. And it was investigated, am I
It
right?
was. Yep.
Okay. And when it was investigated, it was found out that Mr. Gregor,
Objection, Judge, it's hearsay.
was it investigated?
It was.
Okay. It found it?
No.
Objection, Judge.
Right, can we, I see Council Sidebar.
So I need to get the witness to the bathroom and one jurors in the bathroom.
Great, thank you. Ladies and gentlemen, do you want a break for a while? The one juror left, so I know we had a late start, so that's why I didn't break. So, seeing no real response, you want to go in the jury room for a minute, or no, yes? Right?
Okay.
No? All right, well, we have to wait for the jury to come back out, so. The witness back on stand, the jury's in the box. Ladies and gentlemen, I sustain the state's objection. The incidents in this case, as you know, are two: March 20, 2021, April 2nd, 2021. Any prior incidents that were just discussed are totally hearsay, based upon things that were said by others outside of this courtroom. If it comes a point in time where those witnesses are called, I'll make a determination then whether it's admissible. Right now, none of what you just heard is admissible, so I guess you can strike it and disregard it. Again, if we reach a point where I'm going to allow anything else in other than those two dates, I'll let you know. I've allowed generally the background of the parties and who they are and how when the child was born, just to give you some background. But these specific instances or allegations you heard about were hearsay, therefore they're not admissible and you must disregard them. Thank you.
So there comes a point in March, I guess, of 220 or January of 220, where you're having an issue with drugs.
Yes.
You testified to that.
Yes.
And at that point, you lose custody of Corey.
Yes.
Am I right? And what was the drug you used?
Methamphetamine.
Methamphetamines?
Yes.
And what is a methamphetamine? I don't know.
It's a methamphetamine. I don't know how to, it's a drug.
Okay. And you lost custody of Corey in, I guess it was January of 2020 as a result of that addiction?
It's around there.
Okay. And did you go to rehab at that point?
I went to a drug program, yes.
Okay. And where was the drug program?
Stress care in Matawan.
Okay. And how long was that program?
About 8 weeks.
8 weeks. And then in March, I believe it's your mother makes an application to start to get visitation of Corey, right?
I believe so.
Okay.
I don't recall.
But you still don't have custody or visitation rights at that point, am I right?
Correct.
And why was that?
Because of the drug test?
So did you fail a drug test after the rehab stint?
No.
So what was about the drug test that made you not able to take it?
Apply for it yet, and to get custody back yet. I was still working on myself.
You were working on your sobriety?
Yes.
Okay. And when did you become sober?
Around the summer of that year.
The summer of 2020?
Yes.
So in the summer of 2020, you become sober, and up until the moment you're sitting here, you've been sober.
No, I have relapsed.
Okay. And when did you relapse?
Probably around December 2020.
December of what year?
2020.
I can't hear.
2020.
2020.
Yes.
So in December of 2020, you relapsed again. Was
Yes.
it the same drug, the methamphetamine?
It was.
And how do you take that? Is that like something called a bump? I've heard that term.
Yeah, you snort it.
Okay,
Yeah.
you snort it.
Mm-hmm.
So when you say the word bump, that means you're snorting a methamphetamine.
I guess.
I don't know.
That's, yeah,
Is that how you ingest it?
yes.
So, in January of 2020, you have a drug issue, you lose custody of Corey. In March of 2020, you still don't have custody of Corey. I believe it's in October, though, of 2020 that you're now allowed visitation.
I am, yes.
Okay. And in October of 2020, you then relapse in December of 2020.
Yes.
Does Christopher know that you relapsed in December of 2020? Did you tell him?
I don't believe I did.
Okay. And did you go back to rehab?
I did not.
Okay. Were you able to get over the addiction at that point?
No.
So you relapsed again?
Yes.
When did you relapse again?
I don't know. I have to think. Maybe February. I can't recall. It was on and off, like once or twice throughout.
February of 2021?
Yes.
And was that the last relapse?
Yes. Yes.
So from February of 2021 until you sit here today, you've been sober?
No.
Okay. So you relapsed again?
Okay, yes, I did. One time, yes.
Okay. What was that?
Probably around the same time.
February of 2021.
Yeah. Mm-hmm.
So sometime between February of 2021 and as you sit here today, you're sober?
Yes.
So, do you know a person named Dustin Wondren?
I do.
Okay. And can you tell me who Dustin Wondren is?
He is my ex-boyfriend.
Your ex-boyfriend. And were you dating Dustin Wondren in April 2021?
Yes.
Okay. And by the way, do you have something called Facebook?
Yes.
And on Facebook, I believe there's something called Messenger. Am I right?
Okay, yes.
And did you and Justin Wondren ever use Facebook Messenger to communicate with each other?
Yes.
Okay. And the day Corey died was what?
April 2nd.
Do you remember having a conversation with Justin Wondren on April 2nd?
Objection, Judge, it's hearsay.
Well, her statements would not be hearsay. So the existence of
Right.
a conversation doesn't convey any content yet, so that objection's overruled.
Thank you.
Do you remember having a conversation with Justin Wondren on April 2nd of 2021, beginning at 2:54 p.m.?
I don't remember it, but
Can I come?
Please. Should identify that exhibit, please.
It's a Facebook,
No, just by numbering.
D4.
Thank you.
You want me to read it?
Well, I want you to tell me if you recognize the conversation
Oh.
between, is that you and Dustin?
Yeah.
So you recognize that conversation?
Yes.
Back for a second. Now, on 4/2/21, what time has you dropped Corey off at Christopher's house?
On April 2nd, you said?
Yeah,
Around 9 a.m.
9 a.m.?
Yes.
Okay. And then you went right home?
I believe so.
And at what time did Christopher ask you to send him the insurance claim information?
Around 3:30.
Do you remember in this Facebook chat, at about 3:49 p.m., asking a person named Justin Boydranda to bring me a bump?
Yes. I see it.
You remember that, right?
Yes.
Okay. So that's the day Corey died,
It was.
okay? That's the day that you don't know what's going on, right? You don't have any idea what's going on yet, right?
Correct.
All right? And you're asking Justin to bring you a methamphetamine.
Yes.
So, and you said that you relapsed in February.
Yes.
Is that true?
I actually, that day I didn't do it.
Okay.
Yeah.
But you wanted to do it.
I mean, yeah, I was very upset about my son being abused.
So you wanted a what is it?
Methamphetamine?
Methamphetamine. Do you recall, on that same time, a little later in the afternoon, where you are saying, can I come over and buy one?
What time was this? 4:03. Yeah. I do, yeah. This is the same text message then? Yeah.
And do you recall then going on and saying, I mean, I could get it by myself,
Yes.
I just don't want that much?
Yes.
Now, what does that mean, I don't want that much?
I wasn't like in active addiction, so I didn't need much. So that's what that means.
Explain to me what that means. I don't.
Objection, Judge.
I
She
don't-
just answered the question.
Can you rephrase the question?
When you said I don't need that much to Justin Boardman, are you discussing with him the amount of methamphetamine that you wanted?
Yes.
Okay. So when you said I don't want that much, it's less than you normally take?
Yeah.
Okay.
I was
What did you normally take?
More than that, I guess.
Well, what was that?
A bump?
A bump? One bump? Well, how big is a bump?
I don't know. Depends.
What does it depend on?
Whoever puts it out. I don't know what you're asking me, really.
I'm asking you what you were asking for.
Methamphetamine.
And how much?
A bump. I don't know how to explain it anyway else.
So on the day that you are complaining that your son was allegedly abused by Christopher, you're asking your boyfriend to bring you methamphetamine.
I did.
Okay. So now let's go to the events. from
Yes.
420.
Okay.
When you dropped Corey off at the gym, Christopher had given you permission to take him to the party.
Yes.
Because it was an unscheduled
Visitation.
visitation.
Correct.
So it's not, it was my scheduled visitation. You requested of him, on a day that's not yours,
Mm-hmm.
if
Yes.
you could take your son to a party in Pennsylvania. Am I right?
Yes.
And he agreed to that.
He did.
You said, sure, take him to the party.
Yeah.
And then, did you agree on a time you were supposed to bring him home?
Yes.
Okay? And did you take him home that time?
No.
You took him home late.
I was late.
You were late.
Yes.
And he was upset.
Yes.
So then you guys had an argument, right?
Yeah, over text, yeah.
Okay, over text. And we saw some of those texts, and we'll get into some of those texts in a little while.
Yeah.
So now there comes a time where after April 20th, that you have visitation again.
April 20th or March 20th?
March 20th.
Yeah. Yes,
You have visitation again,
I did.
right?
hmm
And your visitation was usually when, on a Thursday?
I think so. Yeah.
But that wasn't bad. So was it?
I think it was Wednesdays, honestly.
Wednesday? Okay.
Yeah.
So how often would you get him during the week?
It depended on his mood,
On whose mood?
the defendant's.
So the court didn't tell you what days you had? If
Well, yes,
Christopher
so
made the
there was a
determination?
court order, yes.
Okay,
That said,
so-
so it was Wednesday and then every other weekend.
So then it wasn't up to his mood, it was up to a court order, am I right?
You're right.
All right, I'm right.
Yes.
So when you just said it was up to the defendant,
For any extra days, it would be up to him.
well, did the court say that?
No.
Oh, so he would give you extra days if you asked him,
Yes.
and he gave it
If
to
he
you.
was in the mood to give me them, yes.
And he gave it to you.
Sometimes.
Okay, but the court order said Wednesday,
Yes.
and he gave it to you every Wednesday,
Yes.
right?
Yes.
And sometimes when you ask, like on Halloween, right? Didn't he ask you once on Halloween? You asked if you could have Corey for Halloween, so he could go trick-or-treating,
Oh, yes. I remember that.
and he said yes.
Yes.
Okay? But every Wednesday was court order, right?
I believe that's the day. I think so. Not 100%
But you
sure.
had him, how many days a week were you allowed to visit with him?
On Wednesdays and then every other weekend.
Okay. So every Wednesday you would see him, and then every other weekend you would
Yes.
see him. So the weekend that you took him on the 20th to the party that wasn't your weekend?
No.
The following weekend was though,
Yes.
and you took him that weekend.
I did.
Okay. So between April 20th and I guess it would be the 27th,
Right, what you say, April.
March, I'm
March.
sorry, thank you, Judge. March 27th would be, the 25th would probably be the beginning of that weekend, right?
I think it was the 28th. 27th was that Saturday, yes.
And wasn't that Saturday the day he had to do the flag football?
Yes.
Now, didn't he stay at Christopher's house that night?
Friday night, yes.
Friday night.
Yes.
It was your weekend though, right?
Yes.
Where did you stay that night?
At my house.
You stayed at your house?
Yes.
Do you recall that Christopher asked you if he could have Corey?
Objection, hearsay.
Why did you leave Corey there Friday night?
Chris wouldn't let me pick him up.
Okay. Did he get to the practice on time? Oh,
Yes.
by the way, did you agree to that? It was your weekend.
No, he wouldn't let Corey go with me.
To home?
To my house. He wouldn't let me pick him up.
Did you do anything about that?
We met at the police station. He wouldn't let Corey out of the car.
And the police department said that was okay?
Yes.
Yes?
They did.
Hearsay with the police department.
Well,
Okay. But the police are like, you would meet at the police station to exchange Corey?
only when he was in a bad mood.
When Corey was in a bad mood?
Christopher.
All right. So you would meet on Wednesdays at the police station if Christopher was in a bad mood?
And yes.
Okay. But if he wasn't in a bad mood, you would meet at his house?
Yes.
And if he was in a really good mood, you would actually sleep over his house?
Yes.
And how often did you do that?
It depended. Sometimes a few times a week, sometimes once. Sometimes just the weekend, sometimes the weekdays.
And how long did that go on?
About 4 months, maybe. 3 months.
And was that in 2021?
Yes.
So if March 20th was the treadmill,
March 20th.
so we're saying from like January to the beginning of March, you were sleeping over his house during this time?
Maybe early December.
Did you guys discuss actually getting a house together?
We did.
Did you actually look at houses together?
We did not.
So up until this point in March of 2021, you still only had visitation rights,
Yes.
no custody.
I had half legal custody and every other weekend, yeah.
Okay, so half legal custody meaning you had them on Wednesdays and every other week,
Yes.
but you didn't have full parental custody.
No.
And why was that?
Because I was working towards getting more custody.
Okay.
Yeah.
And how did you do that?
What do you mean?
How did you do that? What was the work you did? Tell me the work you did.
I got clean, and I was trying to go back to court and ask the judge for more time with Corey.
And that's just around the time that you had made an emergent order.
Yes.
You requested an emergent order
Correct.
to get custody of Corey and have it taken away from Kristen.
Temporarily.
Temporarily.
Yes.
Right? Because you saw bruises on Corey.
Yes.
And you immediately made an emergent application. By the way, weren't you at the football practice?
I was. Yes.
So now you see the bruises on Corey, you make an emergent application, and that's denied.
It is.
And as a result of it being denied, you then get an order from the court that tells you and Christopher that together you should make an appointment with the pediatrician through DCP&P.
Correct.
You didn't do that, though.
Yes, I did.
No.
I took him to the pediatrician.
You did.
Yes.
You didn't do it together with him, as the court order had stated.
No.
Okay?
He
You
did what he
decided
wrote.
on your own. Did you decide on your own
Yes.
you were going to take it?
Yes.
You violated the court order.
I mean, I don't think it said he had to be present during that. It just said that he needed to go to a pediatrician. So.
I know you about that all day. So now, you take him to the pediatrician.
I did.
Take him to Ivy Pediatrician.
Yes.
And at Ivy, they tell you that, these are some bumps and bruises, suspicious of child abuse.
Yeah.
Am I correct?
Yes.
And at this point, you don't know anything about the treadmill that we just saw.
No.
And they recommend to you that you take him to Jersey Shore Medical Center at that point.
Yes. Well, community medical center first.
Well, I think they said Jersey Shore Medical
Objection, Judge, it's hearsay.
Center. Did they?
They said, well, like,
Right, so it's hearsay, but in terms of how she reacts to that, I'm going to allow it not for the truth of the matter, but for where you took the child.
okay, thank you, Judge.
Yes.
So you took the child to,
Community medical center.
and when you got to Community Medical Center, they also did an evaluation,
They did.
and they said, and you then, as a result of that, took him to Jersey Shore Medical Center.
Because there is a child abuse pediatrician there.
Okay. So there was no child abuse pediatrician at the other two hospitals?
Not that worked with DCP&P.
So when you got to Jersey Shore Medical Center, that's when they told you, you should leave him here overnight.
No.
No, they never told you that? You never signed a piece of paper saying that you were leaving against their medical advice?
At community medical center, I did. Because they wanted to transport him in an ambulance, and I said I was going to drive him. They didn't tell me why, but yes, I signed that.
Okay, so you signed it out.
Yes.
Okay. So now you take him to one hospital, one doctor,
Yes.
take him to one community hospital center, and then you take him to a hospital, and you're doing this all because you think he's being abused, right? And then...
And it was under the advice of a DCP&P worker.
Okay. And then you take him, you try to bring him back to his house that night, right?
Yes.
And you're unable to do that,
Correct.
right? Instead, you take him home,
Yes.
you go to sleep with him,
Yes.
you wake up the next morning, and you bring him back to the person that you say is abusing him.
Correct.
Did you contact DCP&P at that point?
No. Not that morning.
No. That morning, you actually decided to sit down with Dustin Vondran and try to get methamphetamine.
Objection, Judge, it's not accurate.
I think the time frame is wrong, Mr. Galucci.
It is.
It's later in the afternoon that you decided that you were going to get,
Yes.
what is it called?
Methamphetamine.
Methamphetamines. So you believe your child is being abused. You take him to 3 different hospitals. You make an application to DCP&P. You don't have custody of your child at this point because you're not allowed to have custody of your child.
Objection,
and you decide.
Judge. That's,
Right, so it's getting argumentative.
I
You have to ask
And
questions.
you
Elicit
decide.
answers.
And you decide. I'm going to try to get methamphetamine.
Yes.
And you actually negotiate with him.
Who?
Justin. Whoever.
Dustin?
Dustin.
I did, yes.
Negotiate.
I never said I was in, I was weak-minded when it came to that, yes. And I was going through a stressful time, not the best, yeah.
Ms. Schron, Ms. Lento, I'm sorry, on her direct examination, gave you a series of text messages between you and Chris that occurred on April 1st of 2021.
Yes.
They are, yes. Is this 5?
I know there's a lot of them. I don't know which one to refer to.
Which one do you want?
Which one do you want? Which one do you want? S9. There's 6.
Just mark as people's S1. It's picture court.
Yes, it is.
Right? This was taken in a park in Barnegat, am I right?
I don't believe it was Barnegat.
You
It
don't
was
believe
nearby, though, yes.
All right.
Yes.
Besides Corey,
Hmm.
who else was there with you?
That was just Corey and I.
Just the two of you?
Yes.
Christopher wasn't there that day?
No, he was not.
It was snowing out that day.
It was. It was December.
Let me know which ones you want. You're here, all of them. You can look through and figure out which ones you want.
Can I have just a second?
Sure.
So it's S5, S7, and probably S8. You remember that Ms. Lento had showed you these exhibits?
I had to look at them. They're just text messages.
Remember
Okay.
you saw those? Now,
Yes.
do you recall if that was the entirety of the text exchange between you and Christopher?
I don't remember. I don't know.
So, what am I up to?
You said before, but that was actually.
Let me show you D5. You recognize it?
Yes.
That's not just a snippet, am I right? That's the whole entire text exchange
Judge, we interrupt, can the state see the exhibit? I've never seen the exhibit before, and you didn't show it when we walked up, can we see
Judge,
it?
I'm sorry, I assumed that since they had snippets from that exhibit, that they had seen it.
Why?
Well, but there's a lot of exhibits, I'm sure, so as a courtesy, you could show that.
Thank you.
So she knows what you're showing the witness.
Just so we can follow along.
Just for where nobody moved S5
I want to see where you're
or 7 into evidence. 8 and 11 were moved into evidence.
Yes, Judge. We're going to move them, but we just want to see if we could have a minute.
4-1, 10:39 a.m. 2-4-1 at 8:52. Can I get that? 4-1 at 10. Here you go.
It's okay, you're,
Can I push? Yes.
So once again, D4 is the whole entire conversation between you and Christopher on that day, am I right?
Yes.
Okay. By the way, on that day, you just testified that if Christopher was in a good mood, you would drop him off at the house. If he was in a bad mood, you had to drop him off at the police station.
Mm-hmm. Yes.
On April 1st, he must have been in a good mood because you dropped him off at the house. You saw the
I
video
don't-
of that.
That was March. On April 2nd?
Yeah.
Yes. He must have been.
All right. So he was in a good mood because you dropped him off at the house.
I guess so.
Okay. Oh, by the way, how many videos do you accidentally have well, not in police possession, but in your possession where it just randomly takes a video of a conversation you have with Corey?
That was the first time.
That's the first time.
Yes.
So the first time you ever record Corey is after you've taken him to 3 different hospitals, right? Or medical centers,
Yes.
right? You made a emergency order request, right?
Yes.
You drove him back to the guy that you're blaming is having all these issues,
Yes.
right? So let's go to this text
The
exchange.
text.
Phone exchange. So this is an exchange between you and Christopher, am I right?
Yes.
That starts on April 1st of 2021 at about 10:39.
Yes.
Okay? This is the owner. That would be you.
Yes.
First question, am I picking Corey up from your place at 4:30? Right?
Yes.
Then you responded with question marks, because I guess you got no response.
Correct.
Okay? Then he says, police station, I don't feel safe you coming near my home. Right?
Yes.
You say, sure, sounds good. You, where are you? I'll be past 7:30, and I will take over and be with my son.
That was Christopher.
Right?
Yes.
Then Christopher again. I have no idea where you are. You will not tell me on the phone. Why is that? You're past your time by the court order, and I want to be there for my son.
Correct. Yeah.
That's actually in evidence. I'm driving to Jersey Shore Medical Center. I'm doing what a caseworker for DCP told me to do. Right?
Correct.
Then Chris, where are you? Right?
Correct.
Caseworker said you have up to 7 days to do this, and you choose to do it now and exceeds your time, which will be subtracted from your next visit. That's Christopher to you, right?
Correct.
Christopher again to you. Feel free to bring him to the police station or Barnegat whenever you're done, and however long you go over 7:30 is the amount of time that will be subtracted from your next visit.
Correct.
Bad mood, right?
I'm sorry.
That's bad mood?
Yeah.
Then you, the doctor sent me to the hospital. Then Mark, I'm assuming Mark is caseworker, called me and said not only to stay there, sent me to DCP doctor at the hospital. Right? That's what you said?
Correct.
Then you said, when's my next visit that you will allow? You to Chris, right?
Yes.
Chris, just let me know when you guys will be arriving down here and I will come pick my son up, right?
Correct.
And you, I absolutely will.
Correct.
Chris, I will follow the court order. Unlike you, I also won't file an immersion application, is what he said.
Yeah.
For the reason, just to spite you. But if Corey doesn't want to go because your mother will be there, that is his choice. You responded, yeah, right?
Correct.
Sorry, he said that it is arguing between your mother and Richie as well as your sister, who was also present during the visit. You responded, sure he did. So was there arguing going on in your house?
No. No.
Then, Chris, to you, just throwing it out there, that we both know that it is against the order, especially when your sister...
Objection, Judge. It's based upon relevance. We're really going outside of the scope of what was proffered. And
Go ahead, I'm sorry, I didn't interrupt you.
no, that's it, Judge. We're going outside the scope of what's proffered, and we did not have the opportunity to go through these messages to see what appropriate redactions would have been made or not made. At this point now, we're just using this really as a way to just get all this hearsay into the courtroom.
Judge, they gave me... This is from them.
I understand that, yeah.
So, the statements between the parties made out of court are hearsay, but this defendant's here testifying to them. In the interest of completeness, if there's text messages before and after the text messages the state has introduced, my understanding is this is on April 1st into April 2nd. In all fairness, I should allow the entirety of those text messages. If I find the need to make any redactions, then I'll advise you that they're given to you, and you shouldn't, if there are any redactions made, you shouldn't speculate as to what the content of the material that was redacted nor the reason for the redactions. But right now, the cross-examination is appropriate in the interest of completeness of the conversation between the parties, generally for the reasons I gave you in my prior instruction, that the addition or subtraction of certain words or statements can change the context of a particular statement when viewed in isolation.
Thank you.
So back to this.
Yes.
So Chris, to you, it's 4/1, 7:33 p.m. Just throwing it out there that we both know it and it's against the order, especially when your sister just got out of jail for drugs. Your response, Chris's response, they present during his visits, or is he making that up? Your response, I'm not in the mood for this. Right?
Correct.
That happened, right?
Yes.
Oh, but I thought that was the reason why you also wanted to have your visit at my place, because of the toxic environment your family creates. That's first to you, right?
Yes.
I'm not under investigation now. I'm not under investigation right now. You are. I'll drop him off when he's done. His response, and now you're spreading the toxicity to our son, trying to convince him that football is bad and those bruises are horrible because he has to be me abusing him, and he knows your allegations and knows why the police have come to the house. Chris, again.
We have to ask her to say that. That's the content of the message.
Right.
Is it being read correctly now?
Yes.
Chris, again, keep spreading toxicity, keep letting him know that it's more important for you to spite me than love him. That is a very healthy mother and son relationship. We wouldn't be here if nobody agreed with me. Chris, I'm under investigation from your ludicrous claim that it had any shred of evidence when you applied for your emergent order, it would have been granted. Keep pulling at strings and separating us further. Thank you for providing, not making a fatal mistake of allowing you to live in the same house with us, because you're a horrible person and you will never have that opportunity ever again offered to you. Chris, to you, right?
Yes.
Try to coach, Chris, to you again. Try to coach them up and see what you need to him as much as you can but also knows the value of honesty and the truth, right?
Correct.
You. That's why they wanted me to take him to the pediatrician. I'm not fighting you. I'm not fighting with you. I'm doing what a caseworker and a supervisor told me to do, right?
Correct.
Okay. They requested me, Chris, they requested me at noon, and I said I would take him next week and not tomorrow at noon because I couldn't get off work. I was informed that we had up to 7 days to go, which they obviously informed you, and you still made the reckless decision to go over your visitation hours and not even inform me. Very immature. Stop texting me unless it is to give me an ETA to the police station for the drop room, right?
Correct.
You called me and asked me to speak to the doctor here, then the doctor told me to go to the other hospital, right?
Correct.
Chris, what was your excuse for not informing me and having me call you at 7:25, 5 minutes before your visit is supposed to end? Get it together seriously and stop being spiteful. Text me your ETA when you have it. The time past 7:30 will be taken off your next visit. You can fight it if you want. That's the way it's going to go. To be, I will not stand for you exceedingly late with zero communication. Right?
Correct.
When we be there, by the way, the court order that you went today and received afterwards says you had 7 days and it didn't have to be done today. You called DCP to talk to them about it. I'm at the hospital. More to come later.
I said you're more than welcome to come.
That's the complete text exchange,
It looks like it.
not the snippet.
No.
So, after Corey passed, did you, your mother, and 2 other people have occasion to go to Christopher's parents' home?
Have a what? I'm sorry.
Go to Christopher's parents' home,
We did.
okay? And when you went there, did you, your mother, and others throw several objects at that house?
My mother was not involved. It was me and 2 friends, and yes, we did.
And at that time you threw eggs,
Yes.
dead goldfish.
I don't think they were goldfish. It was fish from the supermarket.
So let me understand this. You woke up on this day, you decided you were going to drive to his parents' house, but before you did that, you actually put the thought in to go to a supermarket and buy fish.
Yes.
And you drove to his house, and you threw the fish. Were they dead? Or did you get fresh fish?
It was fresh. It wasn't fresh. It was
Well,
food.
did you get it from a market that had one of those tanks?
No, it was no.
What
It
kind
was
of
a dead fish.
What kind of fish?
I don't remember.
Was it expensive fish?
Not really.
All right. So you got cheap fish.
Yeah.
So you got this fish, meat bones. What's a meat bone?
I don't remember that.
And goose eggs. Goose egg stones.
Oh, stones. Okay.
What is a goose egg stone?
I don't know.
Just
It sounds like a stone, but
so you throw rocks. So you threw rocks, dead fish, bones, and eggs at Christopher's parents' house?
yes.
By the way, did you ever set up a GoFundMe page when Corey passed?
I didn't do it directly myself. No.
Was a GoFundMe page set up?
Yes.
By who? Do you know?
I'm not sure. I can't remember that.
Was it set up on a website or a Facebook group called Justice for Corey?
No.
Do you know what Justice for Corey is?
I do.
Okay, and who set that up?
That was me.
You set that up. And in the Justice for Corey site, was it posted that you had a GoFundMe?
It could have been.
Oh, you're the administrator, aren't
I
you?
am. It's been a few years.
Okay.
There's a lot of posts in that group.
Okay, well, you're the administrator.
Yes. There's other ones too. Yeah.
Okay. How many administrators are there?
There's 2 others.
2 others.
Yes.
Okay. So I'm assuming the administrator, I'm not a Facebook group guy, but I'm assuming that, and you tell me, maybe I'm wrong, but a Facebook group administrator gets notices when things are posted on the page.
Yes.
Okay. So you're the administrator?
I was.
So
Yes.
you got
I
notice?
am.
Are you telling me you didn't know that on the Facebook for Corey webpage, there's postings up there for a Justice for Corey Cash App and GoFundMe?
Possibly, but there are a lot of posts that went up. The group was very popular.
Did you earn any money from the GoFundMe page that was set up?
Did I what?
Earn any money from that GoFundMe page?
I did.
Okay.
Yes.
How much money did you earn from the GoFundMe page that was set up that you say you know nothing about?
I knew it was set up. I'm not the one that set it up, and I don't recall who set it up.
But you profited.
I did. Yes.
All right. So how much was?
I don't recall.
So do you recall how much the GoFundMe was for?
No.
Are you also aware that in addition to the GoFundMe that you made money off of, they also started a Cash App campaign?
I don't remember.
You don't remember?
No.
Just like that, a minute.
Sure.
Judge, may I show the witness?
As long as the state knows what you're showing.
Oh, I'm sorry.
Sure.
Thank you.
Ladies and gentlemen, I'm going to allow Mr. Gallucci to show the witness a couple of documents, and then we're going to break for the day. We'll find a good spot to finish up, and then I'll give you your instruction about recess. Mr. Gallucci.
May I approach?
Yes.
Ms. Micciolo, let me show you something. This is Defense Exhibit D6.
Yes.
Do you recognize that?
I see it. Yep. I recognize it.
And that is a request for people to donate you money on Cash App so you could attend court hearings.
Correct.
So, and the reason they set up the Cash App, am I right, is because when you set up a GoFundMe page, they take too much of profit.
She said that, yes.
Okay, so you agree with that?
I don't agree with it. That's what she wrote.
But you got money from that.
Objection, Judge.
I did. Yes, I said that.
Somebody else said it's hearsay.
Yeah, I didn't post this, so I don't.
But you got money from it.
I said yes.
Okay, you got money from Cash App and you got money from GoFundMe.
Yes. Can I tell you what that was used for, or you don't want to know?
Well, we'll talk about it tomorrow.
Okay.
How's that?
Cool.
All right, thank you. So, ladies and gentlemen, we're going to take a break. Ms. Micciolo, your testimony is going to continue tomorrow, so please don't discuss your testimony with anybody, and then come back tomorrow morning and we'll call you in, okay?
Thank you.
Thank you. You can step out. Ladies and gentlemen, I'm sure you know what I'm going to say, but it's even more important now. You can tell we have news media coverage about this. If you get home, if your friends or family ask you anything like that, don't be lulled or convinced into speaking about it. It's more important than ever that you decide this case only based upon the evidence introduced in the courtroom, not whatever is going on. So please blame it on me. Tell everybody you have a strict judge, and the judge told you absolutely can't have any discussion. Don't even say it's a criminal case. Don't even say anything at all about it. And you're going to wait until you've heard all the evidence, received the summations of the attorneys and my instructions. So don't discuss anything with your friends or family. Don't put anything on the internet. Don't do any research. Don't look up anything. Don't look for any of the potential coverage that may be going on about this case. If someone should speak to you, would say something to you, blurt out something, don't tell your fellow jurors. Tell me or a sheriff's officer or someone in jury assembly immediately tomorrow morning, and we'll address it with you individually. But if a family member starts saying something to you, simply tell them, don't talk about it, I don't want to know, don't look, avoid it, because it's a slippery slope, and that's why it's so important that you follow that. Again, report tomorrow morning about 9 o'clock to jury assembly. Don't come directly to the courtroom. We'll try and get you over here as quickly as possible. If there's any delays, it's unavoidable, but I'll try not to allow for any delays. Anything further from the attorneys before we dismiss the jury?
No, Judge, thank you.
Oh, and
We have to move into evidence, I know you.
right, do you want to do those two exhibits now?
Yes, Judge.
Go ahead.
Let me just get my list. What do we have to move?
The two you didn't address were S5 and S6.
Yeah, we move into evidence, S5. And then we got to move in S6 as well, Judge.
No. No.
You didn't address 6, I think you addressed
S1.
S1.
5 and 7. Well, 1's already in.
Right, so it would be S5 and then S7 that we would have to move.
Mr. Glucci.
I don't have an objection.
All right, S5 and S7 amendments.
Thank you.
So if you have to notify your employer what's going on, you can just tell your employer, I'm still in jury duty, the case is going to continue. Same thing for any immediate family, but that's it. No other further information besides that. All right, please remember your devices and any belongings you have in the jury room. And we'll see you tomorrow morning. Thank you so much.
You can leave. If you got your stuff, you can leave. Yes. Yes.
I'll never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast, I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last. Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.